Hello, hello, hello. It's Attorney Mike Gravel coming to you from Chicago. As usual, it looks like we're resuming, so let's get the party started, shall we? And so it begins. And so it begins. I saw somebody super chatted me earlier. I'm going to try to hunt it down. Holy Toledo. The comments are out of control. We haven't even started yet, and the I love it. Absolutely love it. What's up, brother? Oh, there we go.
How are
Thank you,
you,
Dorothy.
brother? Let me give my
good
goodbyes to Kurt, because I think it would be inappropriate otherwise, but I'll be back.
Okay. Thank you. Oh, thank you. I don't know. Did they get through all the jury instructions? I literally was out. Oh, thank you, Miranda. Thank you, Duncan. Grounds. Pre-trial. All right, it's all's quiet on the Western Front here.
I did my best efforts. Yeah, he's praying to Jesus.
Oh. I wore my Wisconsin Solidarity outfit. I am Wisconsin. Even though I've only been to the state a few times. In case they need me. Oh, look at that. Thank you. Judge Bryant. Ooh. I've got a couple of good sovereign citizens in front of Judge Bryant. She does not have a lot of patience for it. It's fun to watch. Thank you, Carmen. Ah, yes, yes. I forgot I had that. Let me find it. Let me find it. Is it in here? Maybe I don't have it.
He's a lumberjack and he's okay. He sleeps all night and he works all day.
God damn it, Mike.
I don't know if we don't have sound or if it's just quiet.
That's from yesterday too. You gotta scan that in too. Okay. And then, do you have the sheets for me? The yellow.
I don't hear sound.
The yellow. His yellow sheets. Yes.
But they might just have it off.
Isn't there a fourth one? No, there's one on your.
That's awesome. If there's no sound, then John can just talk nonstop.
Shut up.
All right, it's 2:00. I'll call the case. State of
I
Wisconsin
hear.
versus Darrell Brooks. Case number 21 CF 1848. May I have the appearances, please?
But it's quiet. Let me see what I can do.
And Zach, what child was praying for the state?
I'm here without prejudice by special appearance. Beneficiary, I'm here under fraud, menace, duress, and extortion. Judiciary, Jennifer R. Darrell. This is a social security SESTQ trust action which you are a real party and interest to as sui juris and propria persona. This is
Wasn't
a
ready.
military admiralty tribunal and maritime law. Title 4 of the United States Code Section 1, which you can see, which states placing a fringe on the national flag is within discretion of president acting as commander-in-chief of the Army and Navy. Is this a common law court or an admiralty court?
The records reflect that the individual known to this court as Darrell Brooks is present in person in custody. He is wearing a dress shirt. I know he has a suit coat, but it's not
Gotta bust it
on.
out.
He's also wearing
It's only
a mask.
right.
The court is not going to address any of the issues that he is raising, as they are meritless. That I would also say the same as to the notes that he passed while he was in the other courtroom. For the record, I did provide a copy of all of those.
I love
to
it.
the state as well. They are also uploaded into the file.
These are our official sovereign citizen outfits.
Record to the extent that he raises objections or lack of consent is noted for the record.
I was about to do that and say that I don't consent to being called that name or identity. That is the trust name. It is not me myself. I don't recognize that name, nor do I consent to being called by that name. With all respect, Your Honor.
Oh, that's a bummer.
And we still have yet to address subject matter jurisdiction, what has yet to be proven on the record.
Yes.
Well, they proved it.
May I receive those original copies timestamped?
Hey, he's as much a litigant as I am a wizard.
I need to make a record of one part of a jury instruction that I do need to advise the jury. It will also be corrected in the packet. I believe within the last year, the jury instruction on credibility of witnesses was modified by the jury instruction committee. And it was just an oversight on the
I'm not
court's
playing.
part to not include. It's really just one paragraph. It was read to the jury at the beginning of the case with the preliminary instructions. But it is a paragraph regarding implicit bias. And so I do think it's important to advise the jury of
Thank
that.
you.
I intend to do that when they come out. And then again, the full instruction will be amended so that it's in the packet that goes to the jury. And Madam Clerk, if you haven't already, if you could print off page 72. It's the it adds a paragraph before the last paragraph that starts with "there is no magic way for you to evaluate the testimony." And again, I wanted to be consistent with the most recent version of the jury instructions and consistent with what was instructed or provided to the jurors at the beginning of the case. And so I will make sure that they have that and so advise them when they come out.
Yes, I have.
John was born on the
Also,
dark side.
I will read instruction 160, closing arguments.
Oh,
Madam
good
Clerk,
Lord.
Just make the change so that.
Were you drinking with Kurt over there?
We missed that.
Couple
Take
shots.
you anywhere.
So it's the closing arguments of the parties, not the attorneys. And so I will just make that correction and make sure it's,
I accept for value in return for value this document. And Your Honor, I requested that I have copies of my filings from earlier, time-stamped.
Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with
I
all
did-
respect, this
Thank
states
you.
receive copies. How come I can't receive the copies of my filings?
You know what? I can give you the print offs, but I can't give you the originals right
It
now.
is-
That's what
It's
I'm
a
referring
good
to.
combo. It
Absolutely
really
get
is.
those back. I guess I
pretty
was
good.
mistaken that you wrote copy on it. I thought you retained a copy for you.
I assure you there was
So,
no
with
plan.
that,
None.
Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later.
Yeah,
outside
I
the
said that
presence of
this
the jury
morning.
After the case has been given to them. Now, in terms of,
This is organic
closing
stupid here
arguments,
that we put together.
I did set a time limit for the parties.
There was no
yesterday.
plan.
Each side will have a total
I can assure you.
1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue.
Oh, he's going to crap
And
himself.
then, time limit willing, the state also has the opportunity to present rebuttal.
But they get to go
have the
twice.
Burden of proof.
What?
And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury.
That
I
was
just talked
my
about the
cold
order of
tea.
the arguments. The scope of the arguments are the content, duration, and form of argument are within the court's discretion. That's why I set a time limit of 1 hour for the parties. And
I beg your pardon. I'm still on coffee.
Mr. Brooks, I will advise you that I certainly will wait and see.
That's
I'm
one
still
drunk
How
lawyer.
you present your argument today. I will certainly wait to see if there are any
Very-
objections
you need to be
raised.
precise.
We haven't gotten
I
there
also
yet.
want you to be aware
We
that
will,
I feel the
but-
arguments are improper.
It may
and
happen.
simply
It
without
may
an
happen before this is
objection,
over.
Please move on. As a clear indication from this court that what you are stating is not proper under the various rules and case law that govern closing arguments.
Nonsense.
Again, Your Honor, without prejudice, I'm here by special
Fair
appearance.
point.
I don't consent to being called that name for the record.
It's noted, sir. All right, then with that, I will have the go ahead. Looks like Attorney Upper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Yeah, two lawyers.
Where would it
One
be
is
displayed?
literally
I'm gonna
sitting
put
in
it,
a
like,
robe with
right
a
here.
hood, and the other
You want
has
me
a
standing
fez.
at this table during.
I do.
Does
Yes.
anyone need
So I
any
would
more
just-
questions about how stupid this is?
And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
I trust it won't block Mr. Brooks' view of the jury, and as long as,
I think this one's for me, John.
So that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection, what is that?
I am taller than you.
You look nuts, and I'm here for it. Thank you, Sabs.
Previously admitted, Your Honor, it's exhibit.
Sabs is the bomb. She gets it.
And 130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but
In
I'm
terms
saying,
of-
I don't understand what's being shown. Should not have the right to ask, to object and ask what it is that's actually gonna be shown.
the state's put on the record what it is. They are exhibits that have previously been received by the court during the course of this trial. That is proper for a party
Thank
to
you.
do that during its closing.
Conus mom,
arguments.
So can I put up exhibits?
if you learn how to.
Mr. Brooks, I don't know
Wait,
what you
lay your
plan for your closing
foundation?
Argument.
That's a thing.
So-
I'm making a request, the same request. May I be able to put up,
Well, I guess it
exhibits?
depends on what it is, sir. So
Right.
I'm
You
not
get, it
gonna
has to
take
be
up
for
any
the
more time
exhibit.
Because what I intend to do is, once the state
What's its
goes to
purpose?
its closing, I may take just a short comfort break depending on how long it is. And if there's something in particular,
Thank you, Courtney.
You will need to tell me. What
See, I
it
get
is.
I get
As
an
long as
extra
it's
super
an
chat
exhibit on this
for
case,
misinterpreting
then
that.
I wouldn't have an
First
issue
of all,
with it.
They would be from this case, obviously.
another victory for Let's Talk with
It's
Mike.
just not nothing that stay there.
Thank you.
I'm not aware of exhibits that the state wouldn't have.
Screw your grift. You're making a fortune off of
Everything
me.
that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or
Yeah,
appropriate.
that's why we're all here, isn't it?
They're part of my filings that you filed.
Filings have no
Exhibity.
relevance to the issues that are before the
Dude,
jury. The
In
closing
it
arguments are
is
to direct
literally the
jury
most
so that they have
northwestern
arguments
thing I've
so that
ever
when
heard
they
in
go
my
back
life.
To determine the issues in this case, which are related to
I believe
whether
you're from
guilty or
Chicago.
not guilty of the 76 charges. Things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the
Comfort
judge
drift
of
money.
the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings
Mhm.
that
That's
was
not
filed.
specific enough,
My-
sir. What are you
My
referring
court
to?
docket
Which
sheet,
filing?
let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done? Are you done?
Sir, that's very rude and
No, I'm
disrespectful.
just, I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What
Your
filing
Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find some way to make it to be something that it's not? I
'Cause
didn't
you're an
know if you
a-hole.
was gonna say something else.
Any more questions?
I've asked a question.
You have
sir,
no
so
idea
when
what
I
the
do
fuck
that,
you're
I
arguing,
would
and you have no
hope
idea how
I'm
to
looking
do it.
For an answer. So which filing
Are we
you
done?
referring to?
All
With
my filings,
specificity.
my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
Chinese phone book,
Requested Display those to the jury is denied. It's not relevant.
your lost
How's it
pamphlet.
not relevant? Not even your
That's my
oath of office.
determination, sir. So I'll take. I'm
Sorry,
going to start this.
that one
Not
actually
even your
got
oath
me.
of
Like,
office can be shown.
No, that is not relevant to these proceedings, sir.
It is.
It's not relevant in front of the jury.
Why is it not relevant? Can you?
Mr. Brooks,
you would know that if you had a
to
lawyer.
be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin,
I said your oath
whether
of
there's
office. I
subject
didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not, none of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know.
No,
the truth
he's right in
their
line.
duties and their rights.
This
They
is
should know
straight-
that at least.
Mr. Brooks, I'm putting.
This
you
is
on
straight
notice
soft
that
set
you
losing.
Continue with this insistence upon
I
presenting
have-
information
oh,
that's not properly before
if you don't
the
believe
jury
me,
as
go to my
evidence
playlist.
In this case,
I've got all the soft set losing you'll ever want to see.
Instruct you during your closing argument to move on.
It's hilarious, honestly.
We're not
I
even
usually
at
ask
the
jury
closing
to have the jury
arguments,
leave so that I
people.
can admonish you And if you keep insisting
Thank
on
you,
that,
Sonia.
that will be in direct violation of the court's direction
So
to
they
you.
can't
Look at this
even,
guy.
They can't even
Hey, Ben.
Hey,
say that I got a
I,
shock device.
sorry,
and
I'm
change it.
eating lunch right now.
Absolutely
Did he
do not
go?
need to know that.
Why
So
not?
it's
Talk about
relevant
maritime
to
law.
the
Did I catch
determinations
that?
of
I was
Oh, yeah.
catching bits and
He was
pieces.
running a Reagan
What
Law
happened?
School, middle of the
Brooks, your
pack.
custodial status is not.
So what?
Was he like a
Uh,
vessel
I
in the
would
stream
argue
of
that it
commerce
is.
or whatever?
From November 21st of 2021 is.
He's
That
doing it
hasn't
all
been
right
proven.
now.
We're in
You may
Admiralty
not
Court.
bring up the way that
Oh
you've been
man,
chatting.
that's
It's
exciting.
not relevant, sir.
It's
And if
the
you
truth.
do so, you do it at your peril, but it's
There
and
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
let me go. Okay.
It's my constitutional
is-
right.
Oh dear.
Just like
There are
under the
certain
First
things
Amendment,
that
which
you
I
are-
preserved my First Amendment right when I came in this morning, I also preserved my
Right.
Sixth
Mr. Brooks.
Amendment right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon.
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It
I
means
don't.
it
Oh,
is not
good Lord.
absolute. It can be restricted.
Don't try
So,
explain it to him, Judge.
Constitution of the United States can be constricted.
Right. Mr. Brooks, I'm putting you on notice that if you.
Yes,
continue
time,
with
place, and
your
manner.
insistence on raising
Restrictions on your
issues
First
that
I'm
Amendment
going to
rights.
raise issues that the jury needs
that
to
are-
know,
They're not.
regardless, because they're under the rights of the United States Constitution, which is the law of the land.
Oh, really?
The closing instructions.
That's funny, Judy.
I'm going.
One of my
I'm
son's
going
name
to
is
let the
Milo,
jury know the
my
truth.
hockey player son.
Their duty and their rights. Under the First Amendment and under the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment.
They can't
of
handle the truth.
Constitution
That's not how
of
that
these
works.
United States.
Very few can.
You can't. No state law can override that.
Mr.
Any
Brooks,
law-
do you intend
any
to
law
keep this up when the
repugnant-
jury comes out?
Your Honor.
Because I need.
No,
to
I
have
do
the
not. That's
state-
why I'm addressing this before they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here. But under the First Amendment and under
What a
the
gracious
Sixth Amendment
person.
of the Constitution, which are rights that I preserve, the moment we stepped in here this morning when this proceeding
Okay.
started, I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or I don't know what I don't even know what that means. I don't even understand that. But any law
Oh, man.
I don't understand the word you said, but I know it's wrong. I know it's wrong.
Mr. Brooks, I'm putting you on notice that you can also forfeit by your conduct the right to present a closing argument. In appropriate circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible with the assertion of the right at issue. The goals that this court has attempted to follow.
All right, I'm
throughout
gonna eat
this
lunch and I'll
proceeding
hop on later,
are
but
multifaceted and multifold.
wanted to see the soft sit
Number one,
stuff.
I do have
Anyway.
an obligation and have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process. It also includes ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom. What I would
love it,
generally
Peter.
refer to as civility in the courtroom. You do not have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules of procedure. While you have a right to present relevant and probative arguments to this jury, you may not. And you may not
That's all we need.
present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court previously. I will give you a fair opportunity to present a closing argument, but again, it is not unfettered. The simple fact is, sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422 U.S. 853, a 1975 case, although in a footnote, it does stand for the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows. And that is, again, sir, you may not bring up matters that are not relevant to the determination of guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not.
No, there's no way you can actually do this properly.
The arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses.
Trying to give him.
You may not convey any idea that you have undisclosed information. Neither party may vouch for a witness or otherwise express personal belief or opinion regarding truth or falsity of any testimony or evidence. It would be improper to ask a jury to draw inferences that the parties know are not true. And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge. And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases
propriety,
referenced
not
therein.
proprietary, but okay.
So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present your closing argument. With that, I am bringing this jury out to complete
Thank you, Susan Cupcake.
the instructions that I need to complete to add to the credibility instruction, the paragraph on implicit bias, and to let them know the full instructions that they receive will have it, to read 160.
Oh, this is going to be a disaster.
And then to have the state go first as they bear the burden of proof.
Now, Your Honor, I'll just let you make your record. I didn't overtalk you. I didn't interrupt you. Is that fair to say?
No.
I let you make the record.
Shut up.
With all due respect,
Please.
when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's
So,
not, I am
I'm
not
not allowed to
required
make the
to give you
record at
that
all, Your Honor?
opportunity, sir.
I'm not allowed
No.
to make the record at all,
No.
No.
as I just let you did, because some of the
Sir,
issues
I
has
have-
I
been.
just let you did.
Some
You
of the
have
issues
told me
has
what
been-
you want to do. I've
Your
told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though
Yes, you have.
everything that you said, you have not proven for the record, and it's unlawful law. You haven't shown one time
Unlawful law.
that is lawful for you to do what you've been doing as
Mr.
far as
Brooks,
your ruling.
once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue.
Oh, good Lord. It's buffering on me now.
Is one crime gonna screw us right now?
Point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with. Point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
You
I'm
will have
going
an
to
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue.
Oh,
Yes,
no.
the answer is yes. All right.
What's going on?
Let me see what I can find.
We've been doing this for days. Fix it,
Yeah.
Mike. Yeah.
Plus,
I'll try.
if you want to check,
Wayfair's White Day is back. Get low prices on thousands of items for your home. Shop bedroom furniture from
Point for you to make
Your
an
Honor.
offer of proof regarding my prior rulings or decisions that you
WISN
disagree
12.
with.
Your Honor,
Seems
I'm
You will
like
have an
going to
it's
opportunity,
inform.
if
I'm going
convicted,
to
to
inform the
raise
jury.
every issue.
Okay.
I can't make it work.
Check WISN 12.
Check what?
WISN 12.
I don't know what you're saying here. Let me see if I can find another stream.
That's what I'm trying to tell you. Oh, Lord Almighty.
That it was prudent on my part to give you some guidance before you potentially do that in front of the jury. But
Okay,
you're right.
but-
I will wait and see.
Your Honor, it's
But
still
I need to get going.
it's still
and I'm going to,
unconstitutional for
sir.
you to
So
tell me that
you
I don't
need to
have
be
the First
quiet.
Amendment right that I preserve, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to
preserve.
have the jury brought out. I expect
that working?
you will be respectful, courteous, and quiet.
Yes.
Or I'll be
And
or I'll be
when
held
this
in
door
contempt.
opens,
Or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
Oh,
Because I haven't
God.
been dishonorable to the court.
Madam Clerk, please have the jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that.
Dear God.
We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what
You don't
are
have no
raising
lawful
are
law to do
essentially
that.
Issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now, because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even,
coming
there's no
out.
lawful law to say that you
I'm
can even
advising
mute me.
you to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Illinois v. Allen.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet.
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you to,
present.
I expect for you to answer questions as a public servant, Your Honor. You're a public
The
servant.
jury's coming
You're
in.
supposed to serve the people. Take me to the next courtroom. Please, take me to the next courtroom. Hold me in
All right.
contempt. Hold me in contempt. Hold me in contempt. Hold me in contempt.
The hell's going on here?
I have constitutional rights that are being trampled on, and you're coming up with ways to make a lawful law
Uh-oh.
where it
Here
doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings,
Your
whether
Honor,
he
I
agrees
haven't-
with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under the First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm
the
not,
way
I'm
that
not
you have
disrupting
through
the
the course
proceedings. You
of
just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not even
the
in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed
I
that the
am
jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
I'm
They're not
asking you to
present.
be respectful of the court's ruling,
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The record
satisfaction. It's
has
about the
been made.
Constitution. It's about what's right.
Are you going to?
Are you going to
follow the
answer
court's
questions as a public
guidelines?
servant on why you're making up laws that are not in the Illinois versus Allen and never utilized the mute button and never said anything about a mute button?
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum and courtesy. He has repeatedly talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize a mute
he
button?
continued to talk.
That's
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
is that
closing
not,
argument.
Your Honor?
You will
Can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant,
invite you back over when it's time for your
You can't
closing
invite me
argument.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom. and
He's
I'll
forfeiting
find
his
him
closing
findings when he's in
arguments
the other
as we
courtroom
Yes,
when I
speak.
can
and
do
you'll
so
mute me, which you
without,
can't lawfully do.
interruption.
You can't lawfully mute me. So now you're trampling over my first.
Oh my God. For the love of hell.
Oh, that's rough.
For the love
That was
of
rough.
hell.
We haven't gotten to the. We're gonna look back on that fondly after we get a incredibly sad and horrible closing argument from the state.
Yeah. I'm a little bit broken, honestly. Oh Lord.
You know, she just wanted to make another record again, but we've done it. Get him out of there, put him on mute, then we can just see him do this.
Yeah.
He can sit there and wave his arms and scream like a banshee. They can hear him a little bit through the wall.
And by God, like, she's given him every chance in the world to come back and actually present a case. And he just can't. He doesn't have the wherewithal. It's just, oh God. It's
He
so
can't do it. But
frustrating.
this ought to be good. We are winding up for something for the big part of the show here.
I think that, best guess, she lets the jury go home tonight and they deliberate tomorrow. And we'll be done by noon tomorrow. Tell me if I'm wrong.
I think this is the scenario.
The wheels of justice are going to roll you right into the Wayne County Jail.
That's the way I see it.
I
Okay,
don't
it won't be Wayne
disagree.
County. I don't know what county it is. Whatever. I don't know. I don't know the Wisconsin counties.
Waukesha is. I can give you that answer in 2 seconds.
And my apologies to Waukesha for throwing a W on the end of their stuff. I mean, I don't know how to spell it, but I'm with you. I am all with you.
Waukesha is actually its own county.
Waukesha County.
Yep.
Ah, tricky when they do that to you.
Every now and again, they actually do it properly.
Okay, I have used up all of my material. You know, I should do this though. For those of you who don't know, this is Kim Blandino. He was up in court today, and Alex messaged me. He's putting a video together. I've already been in contact with Ben. I think Ben and I are going to be doing a stream on that. Once our Nevada Judges drops it. John, they thought this guy was bad until they met Brooks.
What actually ended up happening? Do you know?
What happened with Mr. Blandino?
Yes, sir.
Well, I don't know because the hearing was today, and I was streaming this trial with a law wizard from Tampa, of all the damn things.
All right, fair enough.
But whatever
Somebody
it
else
is,
tried to do
he
a-
was up on a probation revocation. I don't know if he's still in custody or whatever. If you guys, if those of you who are around a lot know, Kim Blandino called me from jail the other day. We had a nice little stream about that.
I did finally catch that.
Yeah, that was a wild one. He called me as when was that? I can't remember. I was like laying down,
That was
and then
like
I get this
3 days ago, 2 days ago.
Yeah, I get this call from Vegas. Well, we'll just leave that alone. It wasn't what I expected.
Fair enough.
Yes, Brooks is absolutely a coward. He doesn't care about the families. Yes, he wanted to drag them through this. Although you see that in these cases when they've got nothing left, there's no leverage. You can see that's why she's not holding him in contempt. If we're sitting there and he's charged with a lighter felony or a misdemeanor, a contempt charge makes a big difference. Because ultimately they're going to get a sentence for a year or something. And if they come and act like a jerk like this, the judge will say, fine, I'll put you in jail for 90 days. We'll come back and try again. You've tacked on significantly to what their expected jail time would be. But here, it just doesn't matter. He's not leaving and he knows it.
Exactly, perfectly said.
Yeah, he's trying to stall everything. It's his last hurrah.
Yeah, but he sucks at that too.
Yeah, I see why she's staying away from gagging him. That to me just is a... If I were defending him on appeal, I would rather have him gagged because I can argue that and say that's just prejudicial all day long. Even though it might be appropriate, It's just a cleaner argument to make.
Fair point. I don't disagree, although I would prefer the alternative. Just viscerally.
My chat's a little naughty. I'm not going to lie to you. Thank you. Latte Olson. Am I saying that right? Or Lottie? Lotte. I don't know how to say that. What would you say, John? Lottie?
Yeah, it's usually Lottie.
Yep. And that was the whole thing where it was interesting to discuss, because it's like, well, you know, how has that ruling sort of changed via technology since then? I mean, I guess the technology probably existed in the 70s, but maybe not.
Not in
But
the
it
same
certainly
way
wasn't
that we have
widely
it now.
available.
Yeah, not in the same way that we have it now.
Yes, the prosecution can, but you don't need to. I mean, you mentioned it in passing. I mean, you know, you can see.
I wouldn't. I wouldn't.
Well, you'll end up saying things like, "Well, you've observed the witnesses and their demeanor," or yeah, you know. Although he wasn't a witness.
Yeah, but why do you need to? You don't need it.
Yeah, you don't even need to say it. They lived it for 2.5 weeks.
Right. So why you don't need it? Why would you bother? I think they're fine. Everybody knows how he behaved.
Quiet in the courtroom, please. We are back on the record. Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because we came out.
Oh, we know why you did
on
it.
the record.
You don't need to explain, Judge.
Following the lunch break, Mr. Brooks was brought to the main
You got
courtroom.
an echo. Is that me?
And during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights.
All soft sit stupid.
He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we are in a court proceeding, in a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct. That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement. It was clear. He made a variety of points. He did so in a way that I would say was very conscientious of people's time. It was cogent. It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument, but he has been removed from this courtroom.
Play a song.
His stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each
Oh, sure. It
case.
happens all the time.
No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have
is a
in
good
this
idea.
brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since he's the only individual there, other than the bailiffs, but I'm talking about as a party to the litigation. So the courtroom, the cameras in my courtroom include one that would normally be on the witness stand that has been zoomed out so as to capture the large majority of the jury box.
Making a record.
I even adjusted the camera that's on the state's table so that the exhibit that's currently up to my left, her right, Attorney Opper, is viewable in the camera angle, and she is still present within, meaning viewable within that as well. And although I've made a finding that he has forfeited his right to be present for the state's closing argument, I'll find that the technology that I have available, it is that his appearance from the other courtroom is the functional equivalent of appearing in this courtroom and being present due to the technology that is available. I do have him on mute for the time being because I needed to make a record, and there is a very lengthy history with Mr. Brooks during this case of him talking over me and my inability to make an adequate record if I am in a constant back and forth with him and trying to talk over him. And so I, yes, made the decision to utilize the mute function on the incoming audio. I know he disagrees with my ability to do that, but I believe it is consistent with ensuring dignity, order, and decorum that when appropriate, he be muted. I will advise Mr. Brooks once again that although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent to the
That's never
concepts of
gonna
courts
happen.
and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it.
Oh,
So
here we
with
go with our
that,
Colin Kaepernick
I will
BS.
advise him that once the jury is brought out, I will unmute him. I expect
don't
that
do
he
that.
will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need
don't.
to go through, including the
Well-
reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point. So should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Your Honor, two quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head, they've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability so that is displayed not only here, but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust
Sure.
accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test,
Yes, could we please?
please.
Oh yeah, that's coming. He's gonna say, "How come I don't have a PowerPoint?" Brace yourselves.
Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable?
They can see it.
All right, and it should be this similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV. And then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen. And then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom. And again, I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate
Objection,
you
Judge.
asking that I make a record
I have
of
big monitor
that.
envy.
I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available should he want them. All right, then are you turning off all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Very good. Thank you.
All right, with that, the jury is to be brought out.
Okay.
No, Dawn, I don't need a nap. I need a shot of freaking some sort of a stim pack.
And after a brief 6-year delay.
All rise for the jury, please. Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you at the very beginning of this case was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, excuse me. And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. Consider carefully the closing arguments of the parties, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
Here we go.
Madam Clerk, if you'll please turn on the PowerPoint. Yes.
Oh, dear Lord. This was a nightmare.
Hold on one second. Mr.
No.
Brooks, do you have an objection?
I thought I was supposed to be unmuted.
You are now. All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you.
Right, that's
Each and every one of you. I
open.
want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodshow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Upper, I'm sorry for the interruption. Your objection, sir?
No, stupid, dumb.
Characterization of who
Don't
I
do
am
that.
And the way it was said, I feel like it was talking down.
All right, your objection's noted. It's overruled. The state may continue.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Darrell. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks? Thank you for your patience in listening to the jury instructions. They must be read for each and every count. But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide while armed with a dangerous weapon. Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then 74 through 75, and then 76.
Thank you, Your Honor. I do apologize.
Oh my God, he actually made a valid objection.
I love it.
68 through 73.
She's like, sure, sustained.
74 and 75 are bail
Yeah,
jumping,
76, not
and
77.
76 is battery.
Good
Oh
idea.
my
I
God.
apologize for that mistake.
He's still screwed, but
We're going to talk about
Yeah,
counts 1 through
objection.
67 in detail. Counts 68 through 73, hit and run causing death, in my opinion, are easily summarized as this. He never stopped. Never. Bail jumping, he was out on bail for 2 files in Milwaukee County facing felony charges there. He was ordered to not commit any further crimes. If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping. Battery, that relates to the split lip and black eye suffered by Erica Peterson. We told the story kind of backwards. We started with the battery for background.
now everyone, he's still screwed. But
First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Darrell. Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human being? Count 1, Ginny Sorensen. Count 2,
Mike doesn't smoke.
Lee
It's just
Owen.
me.
Count 3, Tamara Durand.
Oh, I got.
He
Count
just
4,
allows me to do it on his
James
screen.
Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks. Those are the individuals who lost their lives because of the conduct of Darrell Brooks. From there, we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life.
I always appreciate your sarcasm.
Now, behind me is State's Exhibit 15. It's also on the PowerPoint. If you choose, you may have this chart with you in the deliberation room to help you walk through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it. But it will be available for you if you ask for it. And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged. To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we use in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day. I didn't charge 5,000 counts. We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the
That's a
people in
great
green.
argument.
People in red are the fatalities. And we presented
We
this
didn't
case
overcharge.
to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving?
If anything, they actually undercharged.
Now, some of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band. The Extreme Dance Team, it's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the Extreme Dance Team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the extreme dance team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The dancing grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't. Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt, there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Opera, your objection, sir?
You specifically, I'm sorry, can I be heard?
Shut up.
Your objection, sir?
I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
I apologize.
We showed you at the very beginning. Remember, our first witness was Sergeant Warner, the man who was the incident commander for the parade.
No.
We put up another map.
Step away for a
I think
second.
it's State's Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional. The parade participants help us prove it's intentional. And the parade spectators help us prove it's intentional.
Excuse me, Attorney Opera, your objection, sir?
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney Opera.
how can speculation be made to what was saw? if
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Opera.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But You do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group.
Ah, Christ.
The parade started. This is the starting point, or at least near the beginning, right? This is the area. We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wanders back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on. And he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going. He comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop anywhere along the way. One of the officers testified to it. I think it was Officer Schneider. This was an accident, and he mistakenly wandered onto the parade route after passing all this. And he mistakenly wandered onto the parade route. At any point, all he had to do was stop. They could have paused the parade. They could have moved the barricades and escorted him out. He didn't. It was intentional. He went on for 4 blocks. 4 blocks. It was intentional. He reached speeds of approximately 30 miles an hour. That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't faze him a bit. He kept going until he got to the end, and there was no more bodies to hit. It's
Your objection,
intentional.
sir?
It's not the way that I would have
Mischaracterization
done it,
of the
but
evidence.
he's doing,
Noted, overruled.
she's doing appropriate work.
His conduct when he left the parade route, we'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came. That shows his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
He never
I
stopped.
didn't even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People are there with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Bunker Squad, shut the hell up.
You may continue, Attorney
I'm not dealing with that crap.
When he finally pulls into the gas station, he rolls down his
I've
window
been quiet.
and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat.
Yeah, respectfully, I'm not going to deal with idiot trolls.
How long are we going to mischaracterize
When
testimony?
we're dealing with something that's actually a really serious
Your
question.
objection is noted. It's overruled. You may continue, Attorney Opera.
Thank you.
They need to know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia walking with Burris Logistics, keeps going, plows through the entire extreme dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. Runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them, keeps going, gets down here to the end, and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They look like bowling pins. And when you saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down.
This would be brutal.
And tell me this does not prove intent. Please play.
Oh, Lauren Friend doesn't even want to play it.
Keep watching the left side of your screen.
Oh my God. Oh my fucking God.
Oh my God. They don't want to play it because it's so.
That's
so
intent,
horrible.
folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going.
Oh,
That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they supposed to think?
It's proper argument. Your objection's noted. It's overruled. You may
I would
continue.
argue that it's,
Attorney Upper.
I would say that it's improper, and I move
Mr.
for a
Brooks, I made
mistrial.
my ruling.
the
I'm
sound
going to
the
mute
sound
you
was
if you don't
sufficient.
follow the rules.
I
Exhibit
move for a
1,
mistrial.
The jury
Exhibit
saw it.
152. Clearly intentional conduct. Clearly intentional conduct. States Exhibit 93. We asked the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings.
Yeah, human
That's
bodies. That level of damage.
This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Vidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes.
And that's probably for the best.
That's intent.
The audio is
The
powerful
flight,
enough.
the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, States Exhibit number 130. Put that up here quickly. Take this. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there and drove south on West
None,
Avenue over
as
to
far as
Prospect
I'm
Court,
aware.
cutting through the yards and ditching the vehicle on Maple.
6 consecutive.
All the testimony about the commotion on
if
Maple.
convicted of all charges.
Eyewitness testimony from Officer Sailors, off-duty police officer who
Mike,
saw
tell me if I'm wrong.
this, saw the defendant, Darrell Brooks. He identified him for you in this court. Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now, remember the interesting thing, folks, none of these witnesses in this area knew anything about what happened at the parade. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in, because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happened to catch a license plate. State's Exhibit 150, there's the front license plate. Definitely a little blurry, but definitely you can make it out. State's Exhibit 151, there's the rear plate. State's Exhibit 175, there's Darrell Brooks in his music video with the same car and the same license plate.
No, Claudia,
There's the
you're
key
right.
to the
It's
Ford
not funny anymore.
that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this, because this man in this picture is the same as this man in this picture, wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade. And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982, on his identification card issued by the state of Wisconsin. In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about, I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks.
Prosecutor's doing fine.
It's the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
Sorry, your objection, sir?
If you say I don't want to be called by that name, I
would
swear to
appreciate
Christ.
The quote unquote language what does she mean by shenanigans and this and that and the third?
Sir, your objection's noted. It's overruled. The state may continue.
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing improper. It's noted. It's overruled. She may
I
continue.
just wanted to be fair.
You'll have an
Now, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal?
Yes, you have a right to a
Thank you.
closing argument, you
I'm going to
idiot.
conclude my comments with
You
this.
know
folks.
that if you had a lawyer.
I can
Show you
rebuttal,
a video, a
jackass.
stitched together video
God
of
almighty.
all the carnage caused by Darrell Brooks, and I apologize.
There are moments when I
This
actually
is
wish that we
important
didn't
that you
have
know
this system of
what he
law.
did. It's important that you think about the women like Nicole White, and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards.
Shut up,
Young
dog
girls
pound.
in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step, every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence, use the map 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please.
It's not how
Please.
I would have done it, but she did a
No, I need
fantastic
one
job.
more. Yes, please.
And leaving it on a video is super powerful.
Go ahead.
I agree. I learned something because she did it better than I would have thought to have done.
Is there no audio?
It doesn't appear to be. But let me ask you out of curiosity. If it comes on, we'll flip over, like, no problem, I'll shut up. It's not the way that I would have ended my closing, but if the material is good, it's not a bad way to do it. What are your thoughts?
I think she did a great job.
I tend to agree.
I'm impressed with the brevity. You can go on and on. This is super tragic. You could go into an emotional nightmare scene. It's not necessary. It's not helpful. I'm sure this video is soul crushing. But that we can't
probably
see.
Speaks for itself. But like somebody said in one of the super chats earlier, there are certain videos that they decided were not going to be for media consumption.
This doesn't need to be oversold. It is so tragic in and of itself.
And I think that she did it in such a clean way without overselling it, precisely like you said. that it's going to be so brutally tragic as they're watching it as we speak. Even Brooks is struggling at this particular piece of media.
Mm-hmm.
If that's the last impression that you leave with a jury before the evening, because he's probably going to do his rebuttal case and they'll probably cut and maybe they'll let the state do the rebuttal in the morning. That's what I want them to go home with.
I don't know if they have to do much. I'm curious whether or not he'll get an argument in or end up waiving it. That's the interesting thing to me right now.
I mean, it's only 3:45, so you got to at least
continue with
presume that
Mr.
there's
Brooks's
potentially a
closing argument here. I'm going
chance.
to take a short break. I'll rise for the jury, please.
You have to presume that he can contain himself for 15, 20 minutes, and then she's going to ask you to do a rebuttal case.
Muted.
No.
The jury should know that they can nullify.
You are muted now.
Oh, she's got no patience at all today.
Thank you. We'll be in recess for about 10 minutes.
All right, so we got about 10 minutes.
Absolutely. Well, it should be interesting when we get back.
I suppose so. I mean, as a practical matter, what do you think his closing would even be?
Well, he doesn't have anything.
He didn't lay any sort of foundation in his actual witnesses.
Okay, he can say I'm not Darrell Brooks. It wasn't me. The state failed to meet the burden of proof. That's wrong, and it won't work. But I'm saying what
is the only one that's actually a legal argument.
You could say that. You could say I didn't intend to do. But then you have to confess that it's you, which he basically has a bunch of times. But you could go the other route and just say it was all a mistake. I didn't know I wasn't something. But he didn't really lay any evidentiary foundation for that argument.
I don't know what evidentiary foundation he laid for any argument.
Right.
All right. Let's say shift back. Oh, it's your stream. But if you want to.
Oh, yeah.
What are your thoughts on how exactly the prosecution handled their initial close? What do you think? Where do you think he might be able to go with it? We talked a little bit about it, but...
Are you asking me?
Yeah, I don't know what else we have to work with. We got like 10, 15 minutes to kill.
I'm just impressed with her. The tendency of an attorney would be to talk too much or get too emotional. I think she presented it all. I think she was quite serious, but she kept it short and she didn't start crying and all that stuff. I'm sure a lot of people in the room were, based upon that video.
Yeah.
But it's almost insulting to overplay this. It's so tragic by itself. To try to dramatize it almost diminishes it.
That is actually, and I want people to recognize this, that is a brilliant insight. Mm. That yes, to over dramatize it does diminish it. And her restraint actually made it a more forceful argument, in my opinion.
And it's hard. And the other thing is, if you think about simple things, John's done it, I've done it. It's hard to deliver a closing argument. She's sitting here, think about it. I know she's been living with this case. and she stumbled a little bit on it, but I still was like, that's amazing. You have to keep all these directions, streets, people, all this stuff going in your head while you've got an absolute maniac making crazy objections, interrupting your flow of thought. While you know you're in front of a jury, you know it's televised, you know people are watching this, so you're self-conscious.
Yeah, that's got to be. I mean, again, I've never been involved in any sort of televised or YouTubeized trial, but I can only imagine how much that gets in your head. And she handled herself brilliantly, in my opinion.
I was so nervous the first time I picked a jury. I didn't know which way was up. I've gotten used to it, but it's still, and I haven't tried hundreds of them or anything, but it's still, and I'm old and I've been doing this a long time. It still gives you butterflies at least starting, and then I mellow out, and ultimately I forget about it. But you're nervous going in.
I tell you, the first time I ever sat at counsel's table, I wasn't technically admitted, and I literally just sat there and shut the heck up until the judge was kind, and we built a little bit of a rapport, and during some of the evidentiary stuff, we could talk with each other, and she wanted my opinion. Like, it was kind of cool. So I got lucky in that regard, but absolutely, while sitting at the table, I shut the hell up. It's so strange to watch Brooks do the exact opposite.
The I like that too. She mentioned the Catholic thing once, whatever, and there's a religious component, and it's a Christmas parade and all that stuff. But I really like not piling on with that either. Certainly mention it. But
I agree
literally
with you
did it
entirely.
one time, and then he's sitting there with his fake religious thing, and that juxtaposition where she's got the right of it, but just sort of casually mentions it, and then he's overplaying, heaping on this. I'm the implication being I'm religious now, and I'm a child of God. You can't judge me.
No, that's a really good thing to point out, particularly because, hang on, I got the dogs barking outside. Give me 2 seconds, Vampire.
Those aren't even your dogs, are they?
No, they're not. But no, I think that you're absolutely right, pointing out that she made the brief point about the religious aspect, but she didn't harp on it. She moved on. And yes, everyone knows that it was a Christmas parade. And that's enough. She didn't pick on any one single thing for the jury to focus on, which is actually really smart in that position, because you've got a jury that's going there with 70 some odd charges against them. Do you really want to fight on the 6 life in prison charges, or do you want to fight on the 61 endangerment charges? Like, what do you? And so she's just giving them enough to come back and have a reasonable conversation about the subject. That's awesome, and it's smart.
Yeah. Another good point. Yes, he was up there. This is super chat. He's up there wasting everyone's time. She did the exact opposite. She'd get a conviction either way, but you can go on and on. You'll lose a jury, even in this sad thing. Like, if you go on for 3 hours, people are just going to check out.
No, I think at some point people are going to get tired, and you're
emotionally overwhelmed. You're wrung out. It doesn't mean you lose the case, but you're thinking, this isn't necessary. Now you're just abusing us,
Well, and that's where I think that having an afternoon kind of break is actually one of the best things that could possibly happen to him, because maybe the jury will come back with an open mind, and I don't think it's going to do anything, but it's at least a hope.
Can she set aside the verdict? Who, the
Can
judge?
she? I mean,
JNOV? Yeah, I suppose it's possible.
in theory, it won't happen.
A judge could do that, but only in a criminal case. I can't imagine them doing it except on behalf of the defendant. Like they're not going to. The judge can't say, "Oh, not guilty." No, you are guilty. A judge could say, as a matter of law, I don't think you've met the burden and do that. But I'm not sure in a criminal context. They can in a civil context.
It can go either way in a civil context. In a criminal context, I do not believe a judge can rule to the detriment of a criminal defendant. That's my best understanding.
Yeah, I think she did a great job too. Like I said, I would have handled it differently. I would have put up with less than her. I agree with her stance overall. I think she went too far, bent over too far to get there, but ultimately gets to the same place. I would have given him 2 chances and rung him up, and she gave him 5. I mean, that's effectively the difference between her and the way I would have done it. And maybe the way she did it protected the record better.
I'm not going to criticize her, honestly, because I'm right there with you. I genuinely agree. I would have handled it differently, but I think that she actually did preserve the record in a way that maybe I would not have. And maybe that's because of her experience on the court. I could always be wrong.
Yeah. All right. Well, let me see here. Wait a second. What is this? Let me figure this out here. Jen, just talk for a minute. I got to work something up here.
All right, folks. Welcome to Law Talk with John. Anybody who has some questions, I am happy to take them as long as they're in good taste. Anyone ready to go?
Let me see here. All right. I'm all good. So here, all right. So here's my question then. I have one. So he can feel at home in his little banker box fort. All right, so what's the over-under on this? Do you think he gets a I'm sure it'll be horrible if he does it, but do you think he does any sort of closing argument, or do you think he just runs his mouth and gets shut down immediately and forfeits it? Because if you go out and say you can nullify this and the court doesn't have jurisdiction, the court has no choice. You can't sit there and spew that all day. They have no choice but to say you forfeited your argument. It's over.
You're right. And to some extent, I think that's part of the reason why they're taking the 15-minute break is somebody's going to talk to him and be like, hey, she's going to give you a certain amount of rope to work with, but if you go too far, it's going to be an issue.
And he wants to go too far. He wants to get shut down. So let's just do it already.
I know that, you know that, everyone knows that, but the record needs to be clear. He needs to do it to himself. That's just the nature of the law. He needs to do it to himself. And he will, probably. That's my best guess. But the question is, how long does he go before that happens? I just don't know. I mean, shoot out a poll. You know how to do that better than I do.
Who's this guy?
Hey.
Hey, Ben.
Wow. Man, she did that in 30 minutes. The prosecutor.
She did. She did a good job, too.
She did. That was fantastic.
And you're doing a PowerPoint presentation, which I'm sure that you have worked up and everything. But you got to talk. You got to wait for the pause. And then you got dummy making objections. That's my thing. We got a lot of questions about that. Can you object on closing argument? Yes, you can. It's a horrible job. It's a horrible thing to do strategically, unless it's super egregious. Unless there are just a few lines that people can cross where it makes sense to object. Very, very, very rare. You can object during trial on evidence till you're blue in the face, but not on argument.
Well, what did he have? Like 3 objections? That wasn't terrible, given the amount of time that she went for.
And given his history, objecting to everything.
I was expecting him objecting to literally every sentence.
Yeah. Well, although he might have been wanting to object more. Yeah, we probably had his little sign up. They probably just went to him occasionally.
Yeah.
It's a matter of how much they indulged it.
High Queen stepped on a bee. But yeah, no, this is crazy. This is, I mean, he's, I don't know. Is he going to do his thing today? Like, is he going to do his closing today?
Well, he's up next. They've got an hour.
Oh man, like
if I'm the judge, I'm just like, let's get this thing done. It depends. I mean, there's no reason why he can't either be done or defaulted on, or have waived his right within about 20 minutes here. Then let the state do a rebuttal, and there should really be no rebuttal if there's no argument. They could have saved a little time and just say something else, but it should be short.
What is he going to
give
say?
It to the jury.
Right now, what is the schedule? I think that we have another maybe 10 minutes, if that, and then he has the rest of the day.
If I'm the judge, I am paranoid at getting this damn thing to the jury before we have some COVID bullshit or something that throws it out. I'm not kidding.
I mean, they still have 14, so they could lose 2.
He's not gonna.
Disease. You only need one person to get it, and one more person gets it, and we got a whole situation.
Yeah.
It's just.
They're all here today. I'd be like, this is going out to you people. I'm staying here till 8 o'clock at night. I want this. Okay, I want this case over.
I think she wants to send it to. Deliberations tonight. I agree with you.
Give the case to her.
I think she doesn't care. I don't think she cares if it goes to 6:30. She'll keep everyone there. We'll just get it done.
The problem is, though, if you go to 6:30 and then give it to the jury, because they have to read a few more instructions. It depends on their procedure, but likely.
They already discussed sequestering. That's already been read in.
But then they have to sequester. If I'm on this jury, I'm like, he's sequestering nothing. I don't have to go to some crappy hotel room. I know how I'm voting on this deal.
I mean, how long is the jury going to deliberate? I mean, what do they need? They need to get in there and figure out who the chairperson is going to be, whatever.
Well, I think I said the world records.
How long does it take to check guilty 70 times? How many charges does he have?
Right.
I mean, I can't imagine it's going to be.
Well, generally they pull. I mean, I've never served on jury duty. I don't know, but what I'm told is that they once they take a 4-person, they pull the jury immediately. Where is everybody right now?
Everyone always pulls the jury. But
internally, like they're just sitting there, the 12 of them, and they're like, all right, let's take an initial poll before we even start doing anything else. Where are we all at? And everyone's going to say he's guilty of sin and everything.
That's not my understanding. Usually polling the jury is after they come back with the verdict.
Well, I guess I'm using that certainly is from the perspective of an attorney, but I mean they'll take account.
I have no idea what happens in the jury room. I've never been back there. I don't think
that's why we did it in trial ad. Oh, we had to go down there, and we had to be jurors for the 3rd years. Well, just the people in trial ad. We were first years. First years, it was like slave labor. Go be jurors for the upperclassmen, losers. Just some of the fun you get into going to law school.
Fair enough. No, all I'm saying is I've never seen what actually happens back in the jury room. So I don't know if either of you have.
Oddly, we're not allowed in there. No, but I've pulled juries afterwards. I've
Yeah,
talked to
I've
jurors.
I've certainly talked to jurors afterwards, but
Well, even after Blandino, we went back and spoke to the jurors. They wanted to talk to us, so we went back into the jury room.
that's cool.
That's a nice food back there, though. They get taken care of. though.
I will take a look at that. I got to see what happened. I'll check and see if ONJ gets that video up and how long.
Oh,
it
I think
is.
so. I just got a text that popped up while I was on here.
We have to weigh in on that. I mean, you once represented the guy, and
So I don't know. I don't know what happened.
And he called me the day before yesterday from jail, for crying out loud. We gotta see what happened there.
I would be fascinated. I did finally catch up on your video, and it was crazy.
That was a wild one. All right, so if you had to guess, does he get through a closing argument? Crazy as it is, does he get up there and speak for at least 5 minutes? I'm sure it would make no sense. Even if he's allowed to make an argument, it'll suck. It won't make any sense as a matter of law. It doesn't matter. Does he do that, or does he not even get to the point of addressing the jury and get thrown out?
Is it 5 minutes over under before he gets actually tossed out of the courtroom?
I think he might not even get there. In my opinion, I think the judge is going to talk to him. He's going to ask him questions. He's not going to respond, or he's going to say subject matter jurisdiction, or I don't understand, something else non-responsive.
Is now present
and it's going to be
in
waived.
the main courtroom prior to courtroom, and he is here. I trust you are ready with your closing argument, sir.
Oh, good Lord. Here it is, people.
Subject matter jurisdiction as well, too.
The request is denied.
Just for the record, I was addressing it for both courtrooms, here in courtroom.
Okay, well, that doesn't...
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
Non-responsive.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually, I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There's no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking.
I think, Mike, you got some feedback echo.
You said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously. Are you asking for another copy?
Court required.
I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
Is it proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction. And I will continue forward with the final stages of this trial, which I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document, as it is not based in lawful law. And it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in
Seems to be better.
the name of a trust, not my name. Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you aware
Please
of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
We are close to pronouncing the word
So that
today.
is a tacit agreement.
Oh, he actually did get it. Oh. We taught somebody.
Record to reflect the jury is coming out.
Oh God, if the jury is out, shoot, what did I say? 5 minutes? Can I go to 2? And we'll play Price is Right.
Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed
Time's
of that, Your
now.
Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand.
He's not gonna
why
make
the
it.
jury deserves
Mr.
to need
Brooks,
to know.
this is your
It's waived.
opportunity to present your closing argument to the jury. Please do so.
So what is the
Informed
bet?
of
Who
that,
has
but
over
the jury
5
needs
minutes?
to understand
Who
the truth,
has
their
2 to
rights, and their
5, and who
duties,
is
as
under?
they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30 plus pages to read.
Did you inform
They will
the
be
jury?
informed of the law.
Did you inform them that they can
Mr.
nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you one more time, this is your opportunity to
going
provide
for
your
jury
closing
nullification?
argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the
You
jury.
cannot say that.
It's true.
Wow.
They have the power.
All
No
right, I'm going
trials.
to
Is that what
excuse
he's
the
going
jury.
I would get you
They should know
disbarred
that
in a
they have the
heartbeat.
power.
Please rise for the jury.
Wow.
He's gonna say it anyway.
Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bajurkas case, BJERKASS, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so. And no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom. I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice. So you can't coerce me into a constitutional right waiver when I have not waived the constitutional right. And I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you
That's
to
not how
present
anything
your
works.
closing argument.
Are you making a judicial determination that you're
Yes.
denying me a constitutional right in
I have
open
not
court
made such
on
a
record?
determination as of yet, but you can forfeit your constitutional rights
Under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court of
Allen.
Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom.
Because it's
Not one
applicable.
time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute
a piece of
being
ammunition
used for something that it doesn't
You don't
even
shoot it
refer
once
to
and
or
you just
pertain
It's not a statute.
Mr. Brooks, the Allen decision, Illinois
It's
versus
case
Allen,
law.
and the Anthony decision, which is State versus Anthony, are two examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular
And
defendant.
that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by
Thank
the
you, Judge.
constitutions.
Which I was denied
Thank
the
I'm
right
not
to
prepared to
be
make
able to
that ruling
testify to.
here yet today, but I will tell you
You
this,
waived
sir.
it.
The time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not be
delay.
taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing
And you
arguments.
made
It's
that
getting
while
real
violating
close.
my constitutional
Sir,
right.
please don't interrupt me
Well,
because you
well,
now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's the third time.
Okay, now you can say
So,
two.
Mr. Brooks, I'm advising you
man.
yet again. The
I
time
don't
has now
consent to
come.
being called
That's
that name,
another
Your Honor.
interruption. The time has now come for you to present your closing argument to this jury.
He's
You
gonna
were
forfeit
brought
it.
back over
I
to this
guarantee you.
courtroom for that purpose.
I'm going to let them
That's
know.
another
I called it.
interruption.
No, I'm going to let them
I
know
called it.
that they have rights and they should be told, informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you are
not
going
trying
to
to give-
let me ask you a
No, hold on.
question.
I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have you just said on the record that they have the power for.
Sir, I direct your
You
attention
just said that.
once
Did
again.
you not just say that, Your Honor?
Sir,
You
the
said I couldn't
jury-
instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you
No,
telling me,
You're
sir,
not.
I'm
that
not
you are
telling you no
going
such
to
thing. I
disregard
just told you what you
Not
just
in
said.
my
Court of law.
directive to you to not raise the issue of jury nullification during your closing argument?
That's
Any
not what
one
I
of us
said.
would be
You just
thrown in
read
jail.
and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkas says and stands for the proposition that although the jury has the power of jury nullification,
They have the power.
no party has
Aha!
the right to argue for jury
Dun, dun,
nullification.
dun.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed.
the-
I just want them
Sir,
merely to be
You
informed.
can
That's it.
call it informing, making them aware.
Yeah,
Whether-
they should be
You
aware
are
of the
not
right.
allowed
We can't
to
mention
make
it.
them
You can't
aware
do that.
of their power
No.
to nullify. That is
can I
an
not make them-
improper argument.
Your Honor, how can I not inform them
Because
that
it's
they
not
have the
Because she
power?
just said so.
How
Because
can I
that
not
is not a
inform them
right
of a
that you
power that they
have, sir.
have?
It's an accident of our
I'm
legal
not giving a
system.
new jury instruction.
That is
That's not
because
what I'm
there is
arguing.
no jury instruction for jury nullification,
Yeah, I'm
sir,
not- I'm
because
not-
it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not
I can't
raise
deal
the
with it.
issue of
I'm
jury
going
nullification
to
before this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power.
Then you do.
They have the power to do that. So how is
It's an
informing them?
inherent power that they have.
Sorry.
They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to
Ways
the
of
case that I just
artfully,
cited, I'd
yes,
cite to
stating
you
that
from
they
the
have
jury instructions, the
power to
law
send a
note on
rebuke
jury
to this
nullification
abuse of
705.
power to say no
What that says,
to this
sir, is
overreach
I'm not going to read it
words
all.
like
It's
that.
many, many pages.
That's
But the
just
bottom line
skating a
is,
fine
it is
line.
improper for a court to allow a defendant or a defense attorney to make an argument or make the jury aware that they have the power to nullify a verdict.
And Your Honor, you just added this last night. That's why I had to sit there for an hour in the holding cell and wait for you to change the whole paperwork, because I brought that up. So you never intended for this to even be an issue.
Mr.
It
Brooks,
never was brought up.
if you
But
think
then
I
when I
wasn't-
raised the issue,
If
Your
you
Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say
then you
that's not what I said. That's
you are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that was not there.
76 verdict forms, and it's ×2 because there's a guilty and a not guilty.
Okay.
For each. No, let me finish.
So
Or
how
you've
did
interrupted
I
me
have why did I
repeatedly.
have to sit here for that, where I could have just went to my cell and had it delivered?
It's time. Give him the hook.
We had this
Mr.
at the end
Brooks.
of last night before you called
done.
recess.
I'm not going to
We
debate
had a
that
whole
topic with
we
you
had a whole
further.
conversation about
Mr. Brooks, you
me
are
bringing up about the jury
defiantly
nullification.
disregarding.
Send him down the trap
this
door.
court.
I agree.
You
Here we
you
go
can
with this.
roll your eyes
Here
at
we-
me
because
all
it's-
you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify.
Would you
any
like,
law,
if you would like,
but then
I
I
will
said-
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes
Yeah,
what I
he
need
waves.
to do in order for
Just
this
call it a
court to
day.
make a full record without you interrupting me.
Finish the rest of the jury
But you need
instructions
to
and send them
be
to
fully
deliberation.
aware that you
We're done.
may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to
Gag
limit
and bind him.
what you say
Illinois
to this
BLM
jury,
lets you do that.
even in a closing
Do it.
argument. And if you're telling me through your conduct, through your words, that you are going to disregard that direction, you will forfeit your right to present a closing argument.
Under what lawful law?
Under State versus Anthony.
That it doesn't refer to that.
State versus Anthony
it
may
does-
not have dealt with
It hasn't dealt with closing
the right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No,
fully
it's
applicable.
applicable.
No, you
because the more
can't change
general
the law, Your
principle-
Honor. You can't change the law. That's
I'm not
practicing law
changing
from the
the law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
The hell do you
can't
think
do
a
that.
judge
Practicing law from
does?
the bench.
She's
You
a judge
are, if you're
interpreting a
changing- if
case.
you're- Your Honor,
That's her
Not
You're
job.
changing.
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing
case
to
is on
do
point.
with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect? for
I
me
will,
to
Your
do
Honor.
that?
I will.
Silent in
All right.
Illinois.
So looking at the Anthony case, all right, and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which
No,
a
why
defendant
are
may
you
give
giving
up
him this
his rights,
courtesy?
waiver and forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there. I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S. 337. They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held that the right to testify is subject to waiver, not forfeiture, insofar as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture or conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be present. And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification. You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor.
Yes, I understand she's talking to the appeals court.
Object to that ruling.
He does not.
Are you willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that.
I'll take them as a waiver.
A new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial.
Right. That sounds like you understand the case when you're.
Sir,
not
what
one
I'm
time
telling
did you. Hold on. I let Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
He seems to think they're peers.
Not
I
one
let
case
you
law
make
that
your
you just
record.
cited made any reference whatsoever to a closing argument.
I think either
Not
of us
one.
would have thrown our gavel at it.
So how is me merely
days ago
informing the jury of the power and the rights that they have? How
No,
is that
because
a
it's not
forfeiture
legal.
of being able to give a closing argument?
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at
Well, that's a
549.
lot of-
That's
that's
a
a
Court
lot
of
of
Appeals
cases.
case from
It's an accident
1991.
of the system.
That is the first
It's
close
not
appellate
the
decision in
system.
Wisconsin to consider
Your
directly
Honor,
several issues.
we can't follow the law
relating
because
to
it's hard.
The jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions in the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification
I'm still good
would
with
run
gag and
afoul
bind.
even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up now.
No.
I'm the only one that has
Yeah,
to
hold
make
up.
rules for closing arguments,
Oh shit.
but not the prosecution. How is that fair? How's that balanced?
Mr. Brooks, I'm squarely faced with your
Because they
defiance
follow the
regarding the
rules.
issue
Because
of
of
jury
the law.
nullification
It's
that
not
is
defiant.
requiring
It's not
me
defiant.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently
No.
object to that.
Nobody
Oh.
cares.
Your objection is noted for the record. But
May
my
I ask
rule
for legal
nonetheless
reconsideration of your
stands.
ruling?
50 years
No.
of
That request is
case law
denied.
on the subject.
May I respectfully ask for
If you want to go back to
matter of fact, I reject that
nullification
ruling and
to
take exception
England,
to
we
that
have
ruling.
almost 700 years.
Oh. He rejects it and takes
For
exception.
For the record, may I request a legal
Game
or factual
over.
basis for your rule? Not one pertaining to being present in the courtroom or testifying.
Time to shut it down.
One
It's
that
time.
specifically talks about
It's past time.
a closing argument.
Honestly, I don't know if there is a case
He
out
is
there
truly
that's
dumb, but
quickly-
he's
All of
not
those
as dumb as he
requests
appears. This is
are
more
noted.
manipulative than stupid.
I will not reconsider. I've
I think you're
put my
right.
findings and my
I
reasoning
actually don't know if there is a case
on the
that's
record,
directly on
and I
point
stand
for
by
a
that
closing
record.
For the
argument.
record, may I respectfully request a written judicial finding of facts and conclusion of law?
No.
No.
Denied.
The next is the
For
interlocutory
the record,
appeal.
may I respectfully move for interlocutory declaratory appeal on this matter?
No.
No.
I'm not the forum for which an appeal would be sought, sir. I cannot
Well,
answer that.
Learn
You,
some
you
law.
referred to it before.
No,
You
she
would need
did
to
not.
direct
your
You-
appeal
I'm
I'm
to
confused, Your
to
Honor,
a court of
because-
appeals, not this court.
No, this is, I'm supposed to be in this admiralty court because you haven't
Wrong again, loser.
is the if we're under Article 3, then we should be in common law court.
We're not
That
now
hasn't
under
even
Article
been
3.
addressed. If we're in a common law court,
You
or
are in a common law
admiralty
court.
court.
We're in
What
a
do you
criminal
think
court
the
in
law
Wisconsin.
I don't even
And
need to
what
address
law
And
and
you're
fact?
losing
Based on what law and
badly.
fact?
It's meritless.
Based on what law and fact?
It's her
I
I
decision.
intend to
Explain
bring
that
this
to you.
jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
Maybe
but
you
you're
violate-
also-
lawyer,
please
you
let
have
me-
some idea
Sir,
what the
you're
hell
just
interrupting
made
me
a
yet
rule.
again.
You just
Goddamn
tried to
moron.
put me under a
Sorry,
rule
I'm
that no
just
one else
getting
was put under.
frustrated.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't,
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to
circumstances
be
of
fair.
this case
She
and your
did.
insistence on arguing
Bring
jury
him out.
You just
Let him
can't
say,
abide by
has
let him say
resulted
jury
in this court
nullification, then
creating this
yank him.
I
rule.
haven't argued. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may
No,
not
you
advise
can't say
them
that.
You
or
can't
make them
do that.
aware
You
in
cannot
any way
inform
that
them.
they have the power
And why not?
jury
Why can't they be
nullification
informed of their power?
because it would violate the Bajirkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury
Bajirkas.
And I'm
out.
going to
Bajirkas.
inform them that they have the
Bajirkas.
power.
And if you do that, I will
Bajirkas.
dismiss the jury and I will declare that your right to present a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based
Then
upon
I make an
how I've
oral
Watch her
outlined
do
that.
motion
it. It's going to be
for-
beautiful. We're all waiting
I'm
legal
for
not
it.
going to
finding of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
present a closing
Under what
argument.
lawful law can
Oh,
you?
she can
And
and
then
she
if you
will.
continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the
What
other
lawful
courtroom
law?
as I
So I'm
complete
being
the
held in contempt
instructions.
again. Is it civil or criminal?
All right. Go ahead.
I-
I apologize. May
I'm
I ask the
trying
court to
to
consider
be on
perhaps
my
an
best
alternative?
behavior,
And
but
I
I'm
fully respect the
Getting
ruling the
frustrated
court
with
has
this
just
guy.
made, and I understand the basis for it. We all know the defendant in his petulance will say jury nullification in the first 3 seconds the jury's in the room.
Objection to that.
She's got the over under on 3 seconds.
Proper
I don't
thing
think
to
that
do,
should
I
be
think,
talked
Your
down
Honor.
Stop
to.
interrupting,
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
allow him to make.
Oh,
his
you should be
closing
talked down
argument.
to.
I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable legal credible argument that's being made,
My
then the court can
goodness.
decide as to whether or not he's forfeited his right to a closing argument.
That prosecutor
we
is
could at
going
least
out of her
try
way to try
to-
and give him an opportunity.
By merely objecting
to
and
behave
the court
himself,
telling the jury
knowing
to
that it's not going
disregard
to work.
and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And
Excellent work by
I think
the
they will
DA.
abide by that.
Seriously.
So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
That's all we
Fantastic.
should come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Your Honor, I
Perfect.
object to that.
Yeah, no one cares, dummy.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom.
No, Jill,
And
nothing
if
about
you
this is
continue
normal.
No.
In a blatant disregard of the requirement that
Could you
not
imagine if this were the
reference
normal?
in any way
Oh,
jury nullification, and may
norm.
leave that final determination outside the presence of the jury.
I object to that, Your Honor.
Nobody
All
cares.
right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling?
No.
So is that a tacit agreement that you
I
don't have to answer
reconsidered
my question,
and
Your Honor?
I decided again.
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Fine.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor?
No.
Denied.
You know what's next. Interlocutory.
For the record,
appeal.
may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor?
Denied.
No.
For the record, may I respectfully move for interlocutory declaratory appeal
There
on
it
this matter?
is.
No.
Court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction
Denied.
No.
under,
The jury
based
is
on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
We know, jackass. Don't worry. And that will be the end of your argument. And you will soon be serving a life sentence.
6 consecutive. God willing.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
Oh, here we go.
Oh, it's on.
Good afternoon. It's been a long day.
Oh gosh.
First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe.
No, don't go there.
One thing that I believe that you have not been privy to is the truth of your rights and your duties.
No.
Being the jury. The fact that you and you alone have the power. Not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you don't agree with.
No. Okay, now you crossed the line.
And there you have it.
Oh,
I
you
will
did
strike
well.
from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech.
Yeah,
No
you don't have
kidding.
a case, idiot.
We noticed.
Looking
Never
at
would have
say
guessed.
certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart.
Your cold, black, dead heart.
What you won't hear me do is argue facts. And the reason you won't hear me argue facts
Because they're terrible for
is
you.
because I believe that it takes away from what should be recognized. The tragedy of this event, it should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that.
You wasted all of our times.
It's a little emotional. I apologize for the long pause.
Oh, shut up. I'm going to try and not speak over him.
It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year.
Yeah, no shit. The rest
For
of your
families,
life's going to be a hard year.
Mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal.
Screw you, you son of a bitch.
Talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it.
No, the
And
more
then
I heard
sit
you,
and
the
go,
more I
I
hate
hate that
you,
song. Why am I singing?
bastard. I'm sorry.
That's what's been happening. Rerun over and over and over and over and over and over and over.
Because there's so many victims.
Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the thing from the prosecution here has been intent.
No shit.
We all know what's been said. We all know the picture that's been painted.
That you're a sociopath? Yes.
Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do?
No shit.
You know, for a year, I've sat and gone through this. Feeling so powerless.
Fuck you for feeling powerless. How about the 6
Let
people
other
you
people
murdered,
run with the
including an
narratives.
8-year-old? Son of a bitch.
Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that.
Nobody else cares about you healing
A lot
yourself.
of it, there's no need to get
Piece of
into.
crap.
I myself in my own life have had to do a lot of healing. As a man with children myself, I find it hard to believe
What do you find it hard to
that
believe?
anyone
Because
who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act.
are you kidding?
I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn.
Are you on crack? You literally tried to run over your
Well,
girlfriend a week before.
Attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to. And I'm sure that the prosecution will beg to differ. But the fact of the matter is,
No goddamn shit.
the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model
Sorry,
was in
I
fact recalled.
apologize for cursing so
Objection,
much on your
statement
stream.
of facts, facts not in evidence.
Was
I
in
know it's
fact
not really
Sustained.
appropriate,
was
and
in
I'll
fact
try
recalled.
to do less. I just can't deal with this guy.
Was in fact a class action lawsuit against Ford
Objection.
for those
Facts not
model
evidence,
for
Your
those
Honor.
model vehicles.
Sustained, the jury will disregard.
Information that you should have been privy to,
I do genuinely apologize.
that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate, not being able to be stopped.
Objection. That is.
It's
completely
information.
inaccurate,
It's
Your Honor.
There's an
information.
objection. Hold on. Go ahead.
Move to strike statements by.
Sorry
Mr.
for the
Brooks.
interruption.
Facts not in evidence, Your Honor. It's complete misstatement.
Sustained.
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did.
What in God's name is the relevance of this to you?
Moments that I'll never forget.
This is just
And yet they
tone
say
deaf.
disregard, utter disregard for human life.
No shit, Sherlock.
Everything is about him.
Oh, this is.
They made
just
reference to
brutal.
a rage. As if they were, or if this particular DA was right there, standing right there. As if this DA is a psychiatrist. I say
We
to
all
myself,
saw your rage during the
what do you mean
trial.
rage? How can you characterize that?
You ran over 6 people with your
How can you
car,
have the
asshole.
audacity to diagnose what someone's brain is? Where it's at, what it's thinking.
I
Why
have
it
a
thinks the way it
decent
does.
idea based upon your behavior. I don't
DA
know that
makes
I necessarily have
references
to be
to
a psychiatrist to come to that conclusion.
blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill. And it doesn't kick in until well within.
I imagine generally after
Blocks.
hitting the first person, hitting the brake would be a good idea.
And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger Then why weren't people immediately harmed?
Yes.
Why
yes,
was
he
someone
is.
with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that
How about drive home?
the vehicle that he
Go sleep
observed
it
was
off.
not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in?
I don't know. And I don't care.
They speak
But we
as
saw what happened.
someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people.
Wait, what is his argument here?
Reference was made to this vehicle.
That it's truly his intent to kill. He would have been more effective
damage,
in targeting and mowing down people, I believe, is what I'm understanding.
No, I'm not
Says
going to
this
come
was all
down.
caused by
I'm
bodies,
going
but
to
then later
respond
turns around and
exactly the way I
says
always have.
hits barricades and
And if
other
Mike
objects.
would like me to leave, he's
Heard
more than
testimony
willing
about
to
hearing
let me go.
loud crashes and things of that nature. But the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant. And the people have been disregarded.
Yeah, how about your victims, asshole?
Makes me wonder, does the DA even care about those people?
Oh, so he cares more about the people he killed than the DA. Got it.
There's been prayers going
yeah,
back every
clearly.
day.
I can't believe he went there.
It's been suffering on both sides.
No, there hasn't.
It's been threats,
Thanks,
hate
Doctor.
mail. because of the narratives that's been put out there.
This isn't a legal argument.
Put out there.
I just want everyone to
The
realize
lies that's been put out there.
I like this. It's just going nowhere. It's beautiful. It's almost over.
Cause my children not to be able to go to school.
No,
Then we can be done with it.
To be bullied. For my mother to have to leave her home and stay at a hotel because she's afraid for her safety. Because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety.
$10 to 2. I guess I have to go.
And what's been equally hard it's not only having to answer the questions from my daughter who was 7 at the time, my baby girl who was 7 at the time, is now 8.
Yep, and she's still alive.
Attempting to answer her questions.
Unlike your victims.
And still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. I haven't been able to hold, touch, kiss.
Wow.
Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen?
How about you
not just for the
held
people,
your foot on an accelerator pedal into a freaking Christmas parade?
but for
Dear
everybody
God.
involved, the community too. How could this happen?
How could this happen? You did it. Oh. How did it happen? You took your mother's car and you drove it, got into a fight with your girlfriend, and then drove through the dancing grandmothers.
No matter how
That's
much
how that
thinking
happened.
you do, no matter how much you try to look at it from different perspectives and listen to other outside perspectives and listen to people that you trust and that you love, still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't.
This is amazing. He's sounding like he's the victim here. It's just so
He did the
tone
same
deaf.
thing during his opening.
I mean, this is the way
Matter of fact,
victims
it never even crossed my mind
speak.
to even attempt to ask myself that because I know it wasn't.
That's fair. I'll take that. I'm a weird dude, but I'm at least honest.
And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine.
Nobody trusts you.
I don't.
So again, I go back to all these exhibits.
Interesting.
DM me and send that information if you have it available. That might be interesting.
Go back to everything that's been shown, everything that's been testified to. Everything you've heard during this whole process, this trial.
I've tried every opportunity to try and speak only during his pauses.
And again, I say the same thing that I said earlier. Same thing I said in opening statements. I'm not reading from any paper, any books. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone, all of you, you have the decision. I'm sure you've taken a lot of notes during this process. Some days are longer than others. A lot of movement in and out of the courtroom for various reasons.
Ooh-hoo.
Remember the power that you have. Don't for 1 second let it be taken away from you.
Okay, fuck you.
I can never understand the position of sitting on the jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made.
Now, if I could pull the lever on the guillotine, I would do it myself.
The right decision. It's almost like that a message, well, not message, but that writing when we're in our vehicles and we got that rear view mirror and it said things are closer than they appear. But it's also another way of saying sometimes things aren't as they appear.
Mother was a smart woman. Is a smart woman. I don't know, one way or the other.
I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
Oh, dear God.
That's how I was raised. That's what I believe in.
He believes in the Prince of Peace. Sounds about right.
None of us are perfect.
Do unto others. So what?
I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses.
Yeah, you hid behind it for about 15
Not
minutes
something that
the other
just started
day.
at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
He's getting very close because the golden rule argument is not something that you're allowed to make during a sentencing issue. You're not allowed to make that argument. And he's getting really damn close to it.
Yeah, well, we're past that. We've already had a full discussion of jury nullification. They're letting him talk.
But
For whatever
No, you're
mistakes
right.
that I myself have made in my life, I've made peace with God. Made peace.
forgive me for bringing something educational in. That's maybe my third sin today.
I'm happy to say that my conscience is clear. And because I believe, I trust him with my life. Nobody will never know why it was his will for this to happen. A lot of lives were changed that day, mine included. God's way is not our own.
Saints, you're not necessarily
No matter
wrong.
how much sometimes
I'm
we
not
want
saying
to
I
question,
agree, but
we have to have faith.
does anyone actually want him to hear
Look
him
inside
crying for
yourself.
himself?
Look inside yourself and make the right decision. Look inside your heart.
No, you can't make that argument. It's not a legitimate argument.
You have everything in your hands now. everything.
God, if I could light him on fire and throw him off a bridge. Not saying I would.
Do what's right.
Yeah.
Do what's right.
Don't make me laugh. These comments. This guy.
Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power. Each and every one of you has a decision.
He doesn't know what he's talking
Right.
about. Well, I'm gonna law talk with John.
Make
I'm
the right
fed up.
decision.
I think people know that.
Yeah, he's run out of steam. All right, we need to end it.
If I'm fed up, then I'm sure the jury is too.
It's hard to think about. My younger kids getting older and at some point having to
Oh, for the
explain
love
it
of God.
to them.
How about all of the parents or children of the people that you murdered?
Kids don't stay kids forever.
How about the parents of the 8-year-old? I don't give a damn about your kids. You fucked them up.
And
I'm
nowadays,
sorry.
kids, frankly,
You
a
did.
lot smarter than we were when we was kids. Tell you that much.
Do victims have a right to be present at sentencing? To speak, I mean?
That is my understanding.
They do here
I'm
in
not
Nevada.
sure. I believe
They're
the
properly
same
noticed,
is.
they can.
I
But
believe
don't
the
know about
same is true
Wisconsin.
in Wisconsin.
I got a letter the other day.
I don't care.
My youngest daughter,
I don't care.
and she's still learning cursive right now, so she's the best writer when it comes to cursive. She'd rather print.
And
She said, Dad, and this is from the letter. She said, Dad, why are people saying all these mean things about you?
because you murdered 6 people and endangered the lives of 61 others. I'm done with him.
I haven't read the rest of that letter yet.
You know, Penny Mac, I don't
Rest of
give a
that
shit
shit
what you
said.
have to say. I'm trying
That's not
to
the dad I
speak
know.
during pauses.
Throughout this year, I've been called a lot of things. And to be fair, I am a lot of things. A murderer is not one of them.
It sure is.
Well,
Never has been, never will be.
certainly the information. and the indictment. So congratulations. Now it is. I mean, there are 6 people that are underground because of you. So that seems about right.
So before I close my statements,
I think he jumped 2 cents saying in his argument, and he doesn't understand how the system works. That's okay.
I just want to say, open your hearts.
To what?
Go inside yourself when making this decision.
You're getting real damn close to golden rule.
Have no fear. Pray and do what you know is right. What you know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear.
Mike, before we end, can I break the rule of Mike the Law one more time and explain what the golden rule argument is and why it's not appropriate?
Think about the whole entire picture.
Obviously, you can always say no.
And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it.
I'm done too. His closing actually
That's the magnitude of
crucifies
the
him.
power that you have.
Makes me hate him more.
Just like this tissue is in my hand, this is everything. You have everything. Be at peace with what you decide.
I will be at peace when you are put away for the rest
Have
of your
no
goddamn
regrets.
life. And God help you that Wisconsin doesn't have a death penalty, because I'd be very
Don't
happy.
let this decision weigh on you after it's over. Hopefully we got a long lot of living ahead of us,
God, I hope you don't.
Lord willing. Don't look back and kick yourself in the behind.
Fuck you. I'm sorry. I can't.
Yeah, this is how he manipulates his baby's mama.
It's been about 3 weeks with you.
That's probably exactly right.
Took a lot of courage and a lot of guts to pause your life for this.
I'm sorry, Mike. I don't mean to do that on your stream. That's not appropriate.
Important things on hold.
I'm losing it.
To basically stop your life. You should be commended for being able to sit up here with this amount of pressure.
Screw you. You're talking about the amount of pressure you
I want
have?
you guys know that's not lost on me. I'm sure it's a lot.
You mowed down an 8-year-old child with your goddamn car. Your mother's car.
You all should be commended because it took courage to do this. I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now.
I'd prefer to be in their position than yours,
guys have the
asshole.
guts to do it. Thank you for that. Thank you for taking pretty much a month and setting it to the side for this.
I knew it'd be a pain in the ass. I didn't realize it would just make me lose my mind.
I know it's probably not proper, but you guys deserve a round
I'll
of
explain
applause.
the golden rule if Michael let me toward the end of the stream. I don't want to talk over him.
Thank you guys sincerely. And I know and I have faith and I trust that you guys know what's right. Ladies and gentlemen, I don't think it's fair to just say guys, but I believe in your heart you know what's right.
Hey, Robert Korea. Nobody cares what you think.
Thank you.
Do it.
I can't believe he finished.
Wow.
Well, that was
So I
Opportunity.
Yeah, they're going to give the state the rebuttal.
Rebuttal. Please stand for a minute. So please stand.
Are they taking a break before the rebuttal? Or are they just going to do it?
Sounds like they're taking a break.
Oh, Lord. No, nobody cares about you feeling bad for yourself.
That's a win. This is a win. That argument sucked, and it's now over. It
Please.
needed to be done.
Attorney Apparai did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue.
I think the state might just rest. I would.
Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family,
I just don't like being
the
told
Duran
what not to say.
family, the Hospital family, the Kulik family, Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones.
Oh, I know
don't
exactly where
know
she's going.
why he did this. I told you that. But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known. You don't have to stand and wonder as he claims to. For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Absolutely. What a
Nice
mic
close.
moment.
Beautiful. Beautiful.
Slow clap. Slow
Now, members
clap.
of the jury, the duties of the parties
Excellent.
in the court have been
Perfect.
performed. The case has been argued by the parties. The court has instructed you regarding the rules of law, which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors, selected for this important duty. You will not be swayed by sympathy, prejudice, or passion. You will be very careful and deliberate in weighing the evidence.
We
I
have
charge
about
you to
30
keep your duties
pages
steadfastly in mind
to
and as
go.
upright citizens to render a just and true verdict. You are
Just
to
so
decide
everyone knows
only
who we're
whether
for.
the defendant is guilty or not guilty of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations. The following 76 forms of verdict will be submitted to you concerning the charges
Mike, shut the
against
hell
the
up.
defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree
We know where they're
intentional
going with
homicide
this.
while using a dangerous weapon? Count 4. Excuse me.
It appears to me that they're going to go to jury deliberations this evening, probably sequester them for one night, and they're going to come back tomorrow, probably before lunch. I don't know if anyone disagrees, but that's my thought process in terms of the timeline.
Oops, I'm gonna hang out a little bit just to see, because I don't really need to see her reading. I'll put it back on, but I know what the verdict forms are. Here are all the charges. Here's a guilty form and a not guilty form.
Right.
I mean, we all know that, but you know,
We've
you
all
have to
seen
go
them
through the
before.
process. Oh, thank you. Yeah,
Thank
this
you.
today. Well,
I
I
haven't
lost
lost
my-
Ben.
Today was precisely why, and earlier in the trial, which I did skip. Precisely why I didn't want to do it. It was interesting. I won't say it wasn't interesting, but it's just, I mean, it's just miserable.
It's the purely procedural aspect of any sort of trial.
Well, that plus, you know, being confronted with the horrible tragedy of it all. Although she nailed it. Those are the two things the two things, and she got them both. That through his closing argument went nowhere whatsoever, but he did two ultimately offensive things. One, saying my conscience is clear, and two, saying I can't hold my baby, with the obvious irony of, well, yeah, there's six other families that can't hold their baby now too.
All right, to literally everybody that's telling me to shut up and not talk, there's one human being on Earth on his channel that can tell me to shut up, and that is Mike. I've said it before. I'm going to say it again. That's the end of the discussion. I'm not referencing it again. I do want to talk a little bit about the golden rule argument that he was getting very close to.
Okay. There are questions about that.
Yeah, there have been a lot of people asking about that. So, one of the fundamental aspects of law in America is that we operate under the law. And one of the things that's inappropriate to do under our First Amendment is to try and invoke religion as a basis for setting aside the law. And one of those aspects is the golden rule, which is Jesus' aspect of what would you do if you were in the place of the other person? You're not allowed to ask that question, period, as a matter of law to anyone ever, because it might lead to a non-legal conclusion. Am I about right, Mike?
Mm-hmm.
And that's what I was saying when I was referring to he was getting very close to the golden rule argument. And you just can't do that.
Well, it was interesting, and I like said, well, we're past it, but it is true. I mean, that's true. That and by the way, this is true in cases all the time. All jury trials happen in the United States at all times. Attorneys know this.
Yeah.
So this isn't some special thing made up to mess with Darrell Brooks. I have to, if I make the argument, it gets objected to. If John makes the argument, it gets objected to.
No, this has been the case for the entirety of American jurisprudence, as far as I'm aware. I don't know what it originally came from, but it's just something that you don't do.
And it's like, and it's sort of contrary. It's similar to the argument he was making about jury nullification. It's sort of contrary. This happens a lot in law. Everything is not intuitive. Law is not just logic added with intuition, and that's the way law works out. It's not the way it works out.
No.
And so he's saying, well, if the jury can in fact do that, then shouldn't they be informed of it? It's dumb because the answer is no. But intuitively it makes some sense. I get the argument he's making, but it's been made a billion times and rejected by courts.
He had so many issues about all of the quote unquote evidence that was kept out because it was not introduced during the course of the trial. There's a reason we have rules of evidence, and generally speaking, it's designed to protect defendants.
And they're damn good, honestly.
But it's
like
also
hearsay is annoying as shit. That came out a lot. It comes out in every trial, but it became popular in the general zeitgeist. You know during that. And there's a good reason, because used to be you just whoever was more popular and had more people say, "Oh yeah, this happened," without any factual basis whatsoever. Well, then you don't have trials. You have popularity contests of people who will vote for you effectively.
Right, and we decided that that was not the function of law that we wanted to live under.
I mean, effectively, like it was the medieval version of who can get more likes on a Twitter post. We'll decide all issues based on that. Well, that's not good. That's not a good method.
What was it? Oh Lord, I forget the name of the term. It was compurgation. That was the medieval concept, and it was basically if you get 10 people to show up and say that you didn't do it, then you didn't do it. And that was the end of the trial. It's an
and of course that ends up with horrible results. And you have things, and it's funny, you have things like the Constitution or the Magna Carta, or you have these grand historical things. And then, of course, your sovereign citizens, freemen on the land types, they take these things out of context, and they don't understand. Yeah, they don't understand that those rights come with responsibilities. You have to pay in.
Absolutely, they do.
Yeah, so it is just a big mess. But you have to have some historical perspective, and you have to know what courts are doing with things. He didn't understand the argument. He pretended to not understand the argument that it didn't specifically mention closing arguments. She explained to him it's definitely on point. It's saying
He actually had a decent argument there.
Well, sure, it doesn't say that, but that's often the case. It's often the case that you're arguing. It may be the most on point thing, and you're saying, well, you can do it with analogous rights. That's maybe the best you have in terms of case law. We also never had a prior case where Darrell Brooks ran into a Christmas parade. So then if you want to be that specific, then nothing's on point. That's how the law works. You have to apply things and analogize them to, because the fact patterns are almost never identical. The scenarios are almost never identical. You have to analogize and make that's what we're doing here. That's what law is.
That is exactly what we're doing here. Is we're trying to find close enough precedent. That's the nature of any sort of common law system. And by the way, I swear to Christ, if I hear one more goddamn thing out of Shyster or Ossiani, I'm going to lose my goddamn mind. I am going to have a conversation with Mike. He's not upset.
All I ask is that you don't respond to it. Don't respond to them.
All right.
If I did that, I mean, I've had, since the inception of my channel, people telling me, shut up, stop talking in your videos. It ain't going to happen. It's not, I've never once done it. It's not going to happen. You just stop. You don't feed the troll.
Well, and that's why I keep saying there's only one person on this channel that can tell me to shut up, and that is you.
However, back to the stuff, though, I thought this was a big victory. And the prosecutor kind of got there and sort of suggested this to the judge, which I found very odd. Judge, I think we should do this. It was a very reasonable suggestion, and the judge was like, okay, but I found it very odd in terms of like suggesting procedure. But nonetheless, it was very reasonable, which is, who gives a shit? Of course he's going to do stuff. Let him go out of bounds. Just this is much better for the record. Even when he mentioned jury nullification, even when he argued facts not in evidence, even when he did lots of things that when he does a golden rule argument, fine, no attorney will get away with it. But what are we worried about? He's being convicted. We're worried about a record and him appealing. And all of those are just more proof that they bent over backwards for him. Let him do it.
I'll let Ben take that one, because I agree with you entirely, so I don't know what I can actually add.
Yeah, no, I'm glad the DA stepped in, because it would have been more of that just going back and forth with the judge. It would have been,
And this way he got his closing argument in, so there's not that issue on appeal where he's waived it or whatever. Like it's going to be on the with his right to testify. Ugh.
I mean, the right to testify issue, I think, actually is a decent argument.
I think Ben doesn't like it.
I could argue that one.
Well, as that was going, it was so frustrating. We're all feeling it. You just want to punch him in the head. That's all you want to do that entire argument because he's a killer.
I agree, and it doesn't mean that I actually like him or agree with his general position. I just think that there's a legal argument there.
Well, yeah, but I thought was nice is as that argument went, I thought this thing is nearing its conclusion, and we are going to get a verdict that stands. I'm happy. It sucks listening to it, but we're going to take our medicine, let him spew it out, and he did all the way to the point where he voluntarily closed. Ben, you said it, and I thought you were right. Like I don't think he'll ever close this argument, or somebody did.
Mm-hmm.
I don't think he'll ever close this argument, and I didn't think he would. That's even better. When he voluntarily says, that's it. All right, I'm done. That's de facto resting.
He made a terrible decision by having absolutely no one there yesterday.
Yeah.
That was a huge tactical mistake.
Well,
and I don't care who he had.
I think Ben and I are going to do the whole Blandino thing when we get a chance to look at it.
Yeah.
I genuinely think
my phone
if he
was blowing
literally
up
had
earlier,
a
so I do
shoe
know the
washer.
outcome, but yeah.
Sorry, go ahead, Ben. I was talking over you. Ben?
Is he frozen? Do we have frozen Ben? Unfrozen caveman Ben.
There we go.
I was talking over you. I apologize.
There he is, unfrozen caveman Ben. Welcome to the show. How you doing, brother?
Hey, I'm all right. Your ways confuse me.
Ah, Lord. No, my point at the end of the day was I think that if he had anyone yesterday as a witness, maybe he could have bought a little bit of time. But he just didn't. And he did not have his witness sequencing. I believe he called 9 witnesses, which is not nothing. It's not great for a multiple murder trial, but it's not nothing. So I think he's kind of toast. I don't know what appellate court would take that up.
Yeah.
I don't particularly see the Wisconsin appellate
he
court.
gets an appeal as a matter of right. So the Wisconsin appellate court will take it up. Well, whatever district he's in, we'll get the case.
Yeah, but what are they going to do?
They're not going to rule in his favor.
Do they even want to read it? Honestly,
no. All right. So, all right, where are we at with it? You want to check in on jury instructions? What it's verdict forms. Every charge, guilty or not guilty, and they're going to read it.
Oh goodness!
Why
waste the ink and toner on the not guilty part?
Oh, in my cases, in John's cases too. I mean, you get civil things. Oh, you get like, okay, so we have this count, and then we've got an affirmative defense, and we've got comparative negligence, and you have to reduce. Oh, sweet Jesus! It's not even simple. It's not yes or no.
It's a very good way of making what should probably be 2 counts into 60 some odd.
Yeah.
Depends on the circumstance.
You're pleading that and effectively the lesser included offenses.
Yeah, so it's not criminal, but in the
what level of
context,
intent are they buying?
Oh, so do they get instructions on lesser included?
I don't know.
I was telling Mike, the way that they usually do it is they literally have a box of like magic cards, and they just pull out each of the ones that you request, put them in order, and then if you want to add the lesser included, they'll pull out the card before that.
But see, usually the defense has to get that, or the DA will bring them in if they don't think they can prove the more serious charge. Then they'll say, okay, you have the option for lesser included.
Well,
But
it depends on the case.
I don't know.
So med mal is a little bit different from, for instance, contract violation. So you could, or I don't know. Sometimes you'll see it workplace injury, lesser included, so to speak. We don't refer to it that way. Would be like a contract violation by the GC to the sub. So it can flip a little bit on that regard.
Wait, where is this? Is this the case?
I believe this is live again.
Question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
I just wanted to have, thank you. I just wanted to have that process for a minute because we've been off forever.
Stand break.
Yeah.
While I confer with Madam Clerk.
Oh, you brought us right back just as soon as they were being done.
Nice timing. Get to see him reading his Bible.
Oh, that was so offensive.
Apparently, he got through half of it over the course of the last 2 days.
You know what? The Bible doesn't say don't run people over in a Christmas parade either. It says it nowhere in there. So
I don't
apparently
think
he's
that's what he
justified
said.
both in terms of law and religion.
God,
so it's not a lawful law.
It's not a lawful law.
I'm
I mean,
pretty
God
sure-
didn't specify. If he wanted you to not run people over in a Christmas parade, why didn't he mention it?
But you know what, Mike? I think "thou shalt not kill" is probably
Yeah,
in there somewhere.
that's exactly the argument they were having. Like, you know what? They didn't mention Christmas parades, but yes, this falls under this heading. It's that killing part's critical. And yes, you can you
33. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety.
Wait, is this actually? Did they already come back?
No. They're reading
The jury find
I had the same thought. What?
the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
That'd be
Count
yes.
34. One reading, we the
This
jury
is easy.
find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in
Okay,
count
they're just
34
reading
of the
through the verdict
information.
form.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 34 of the information.
Yep.
If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 35. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 35 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering
so she is
safety
going to
as
make sure
charged in
that
count
it's done
35 of
today.
the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
Now, private jury is always a good idea.
Count 36. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 36 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 36 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the
Can you
defendant
imagine
commit
the
first
danger
degree
if
recklessly endangering safety while
we
using
were
a dangerous
actually
weapon?
required
Count
to state
37.
our votes on the
One reading,
record
we the
on
jury
guilt
find
or
the defendant,
innocence of a criminal
Darrell E.
defendant?
Brooks, not guilty of first degree recklessly endangering safety
Bad
as
idea.
charged in count 37 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety
No,
as charged
just
in
reading
count
the verdict
37 of
forms.
the information. If you find the defendant guilty of first degree
Oh,
recklessly
man.
endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 38. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 38 of the
So when you
information.
figure if they're
Another
charged
reading,
tonight,
we the jury find the defendant, Darrell E. Brooks,
you
guilty
figure
of
9
first
o'clock
degree
your time
recklessly endangering
tomorrow,
safety
they'll
as
have a
charged in
verdict.
count 38 of the information.
Well, how
If you
late are
find
they
the
staying?
defendant
Have they
guilty of
said?
first degree
how late they'll
recklessly
keep them?
endangering safety,
They
answer
said
the
they would
following
sequester
question,
them
yes
for
or
tonight.
no. Did the defendant commit
believe.
first degree
It-
recklessly
it-
endangering
it
safety
at
while
least
using a
came up.
dangerous weapon? Count 39. One reading,
Mike might
we
know
the jury
better.
find the defendant,
I wouldn't be
Darrell E.
surprised if
Brooks,
they decide
not
on their own
guilty
they want
of
to
first
stay
degree
late
recklessly endangering
and get it
safety
done
as
if they're
charged in
making
count
progress.
39 of the information.
Do you think it might
Another-
come back tonight?
I wouldn't see that as out of the realm of possibilities at all.
Well, I guess what is it right now? It's almost 6 o'clock over Central Time.
Yes, it's almost it's 3:55 here.
So if they read the verdict forms and they get done by 7, I could see the court running it till 8:30. What do you think, Mike? It's your wheelhouse. You're muted. Mike,
Can't
you're
hear you,
muted.
Mike.
You're
Can't
muted.
hear you, Mike. There you
It
are.
would help if I wasn't muted, huh?
That might
A
help.
little better.
Okay, well, I'm just going to leave this going in the background. I'm not going anywhere. I'm here. And we're going to find out sooner or later, and you guys can hang it or not, whatever, that's fine. I'm not going anywhere, but I'm just going to let it run in the background. When they get back, the jury's going to go out, and they're either going to have to come back and say, they're either going to decide, hey, we're going to come back tomorrow to deliberate, or they're going to start deliberating right now, in which case we can get a verdict like that.
I agree.
Well,
I, think
I
that's
haven't
crazy.
seen her dismiss them yet. And
Yeah.
I at least know in New York, they sometimes would hold people over until 8:30 or so to try and see if they can come to a conclusion.
Oh, I would want to.
And
If
I
I'm
don't
this
know if they
I'm
need
this
that.
jury, if I sit
That's
here
what I
for 30
think.
I'm like, this guy's guilty. Let's get this done. I don't want to stay in a crappy hotel tonight.
Right,
I'm
and we
gonna
can be
sleep on my
done
bed.
today. Right, and they're done and don't have to come back tomorrow.
I'd be like, I'm willing to do it, whatever, it's my job, but let's get together and poll each other and just see if we're there or not. Like, give us an hour to look at it and see if we can get it done.
Yeah. I just don't know what's customary over in the Midwest. It's not really my wheelhouse.
Well, what I'd like to see is I'd like to see him drawn and quartered. But I haven't seen that actually occur for a while.
It's been a little while since that. I think you might still be able to get away with that in Texas and Florida every now and again.
I'm not doing this. I walked on the damn Summers jury. My guess is it doesn't happen tonight and we get a verdict tomorrow morning.
That's kind of my guess.
As we sit right
but
here.
It
But I'm
depends
not going
when
anywhere till the judge dismisses them for the night.
it depends when she gives them the charge and what the actual timing is going to be.
I mean,
I
I would see if
would
it was
like it-
close, but she's in the middle of it right now, so she's got another 10-15 minutes of reading this nonsense.
Well, like I said, I would like it if the judge would say, hey, I'm going to give you the charge. It's 7:30 local or 6:30 local. Go for an hour. If you can't figure anything out, then I'm going to sequester you for the rest of the night and figure it out.
Absolutely. If I was a judge, I'd say, whatever, we've been through hell. Let's have this isn't a late night for no reason. This isn't late night to decide whether or not you're done with your service.
Right. And they've sat through all of this as much as we have.
I got to imagine they would want to get this done tonight. They want this done more than any of us.
All right, wait a second. Let me do that. Let me see if I can figure this out. Just a second.
And you say crappy hotel. I got to tell you, here, I'm pretty sure they sequester juries at the Golden Nugget down on Fremont Street here in Vegas. So they might want to go do some gambling.
Yeah, but they're not allowed out of the rooms. I guarantee you in Tampa, not quite as posh livings.
No, not the circus. Oh, gosh.
So I could imagine what the hotel circumstance in Waukesha, Wisconsin might be. Would not probably be
Did
my
I do
first.
this?
What is this?
I'm trying to do a poll here.
Probably would have helped Darrell Brooks to stay in a Holiday Inn or whatever that one is that makes you smart.
Oh, well.
I'm not an attorney, but I did
that
stay
obviously
at a
didn't
Holiday Inn
take
last
place.
night.
Oh my God.
How's the
I can't
poll
see it
coming?
from my end, but I can pull it up. Let's see.
Oh, Holiday Inn Express. Is that the one?
I'm actually curious what other people think because I was just asking you guys, and now I want to know. Okay. Did that work? You guys don't know because you're on stream with me.
Yeah. We don't get to
I'm
see it.
asking the wrong freaking people.
Pat Cummings. I don't know if you can still play Keno. I would assume you still can.
You, Patricia? Look.
And it did work.
I know I want to do the Blandino video. We'll do it. But I'm not walking on this verdict. I went and I had so much stuff to do. I was strung out from that too. And then I was at the gym actually. And then I'm coming back and I see on my phone that the verdict came in.
All
on
right.
Summers. After I bled on that case for days.
Keep flexing on the fact that you were at the gym.
I was at the gym.
I was not. I was getting
Right.
lunch.
I was making mad gains, people.
The gun show.
Making mad old man gains at the gym.
So what's up with Blandino? I didn't hear about this. I didn't see anything. You want to?
Well, he had a thing, and then Alex at ONJ got the hearing, and I'm sure it'd be interesting, and we'll do it. But I don't want to leave here. The minute I walk out of here, they'll come back with a verdict, and I'm not doing it.
Yeah, that's
I learned my
Video
lesson.
is 11 minutes long. That's all.
It's only
No
11
long
minutes
one.
long.
Yes. 11
My
minutes,
last case, I literally-
47 seconds.
We'll knock that out after this stream will end one way or the other. If I would say this, if they're not inclined, if the judge is not inclined to let them to give it to him, like, I mean, she's going to read the instructions and give it to him. But if she's inclined to say, no, you guys are going to take too long, you're sequestered, go, for the night. We'll know that soon.
That would be a strong decision. I'd be shocked if they.
It's only 6 o'clock. I think you give it
like
to them.
8 o'clock.
Well, they gotta. Well, how much longer do they have to read the verdict forms?
Maybe 10, 15 minutes. The verdict forms are only like 30 pages.
You find the defendant guilty of first degree.
So, Mike, with those gains, does like another button come undone on the shirt, or how does that work there with the mad gains?
I genuinely don't doubt that they're just going to sign all of them, be like, please let us go, throw him in prison for the rest of his life, get us out of here.
It's like me at a closing. They just hand you a stack of documents. You have no idea what any of them say. You just like, give me a stamp. Let's go. Yeah, I want the house. Okay.
Do not say that publicly.
Or I want you to have the house. Either way, just let's be done with this nonsense.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree reckless.
I don't think they care at this stage of the game. I think they've already made up their minds.
Find the defendant guilty.
Has he turned a page on his Bible?
No. She actually noted that for the record yesterday.
What happened here?
You can add them to this. Yep.
He picks a random page, opens it up, and pretends that he's actually reading.
She's on count 56. Thanks, Kat in Virginia. I love my peeps, keeping me updated.
56 out of
56 out of, what is it, 68?
67?
Somewhere in that ballpark. We might actually get jury deliberations tonight. Because it's only 6:06 over in your time zone.
Count 56. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 56 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 56 of the information.
I think they might go
If
to
you find the defendant
deliberations
guilty
tonight.
of first degree recklessly
And I think
endangering
it might be
safety,
done.
answer the following question, yes or no.
I mean,
Did the defendant
historically,
commit
the
first degree
quickest
recklessly endangering
deliberation
safety while
in
using a
American
dangerous
history was
weapon?
9 minutes.
Count 57. One reading, we the jury find the
This one
defendant,
might give it a run
Darrell
for
E.
its money.
Brooks, not guilty of first degree recklessly endangering safety as charged in count 57 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the
Will
defendant
react to
commit
the
first
verdict
degree
by
recklessly
being
endangering
put in
safety while
handcuffs
using a dangerous
and
weapon?
being removed to state custody.
Count 58. One reading, we the jury find the defendant,
That's how you
Darrell E.
react
Brooks,
to
not
a
guilty of
criminal
first degree
defense.
recklessly endangering safety as charged in count 58 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information. Recklessly endangering safety.
So we're getting there.
58 out of what? 70?
58 out of
76, I
I believe,
thought.
76.
Okay. I'm just like I said, I'm gonna pause this. I gotta eat something, honestly, and I got a deal. I'm going to be right here. When things change or we find something, I'm coming back on. That's it.
All right.
So I'm just gonna mute my microphone and stop my camera for now. But I'm gonna be listening the whole time. And as soon as we get updated information, I'm gonna come right back on. Anyone who wants to join me, all good.
I'm gonna probably nuke some food, so I might mute myself as well. But I'm cool.
But I'm not going to close the
All
stream
right.
because that could be 5 minutes from now. It could be 2 hours from now. I don't know. But I'm not going to make you guys sit here and tap dance for 2 hours if it's that.
That's all right.
All right.
That is fun. I'll play with them.
But the stream will be up. I mean, you can chat with people if you like. That's up to you. If you want to keep my stream going, have at it. You know, I'm not
Go
going
for it.
anywhere. I got to do some other stuff because I've been here all day, like you guys.
All right. Yeah, hang on. I need to make another phone call.
I'll put it back on
work
so we
during
can all
this.
see it.
But yes, I'll be right back.
Degree recklessly endangering safety as charged in count 6. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 62.
All right, welcome to
One
Law
reading.
Talk with
We,
John.
the jury, find the defendant, Darrell E. Brooks,
How are you all
not
doing?
guilty of first degree recklessly endangering safety as charged in count 62 of the information. Another
We're gonna
reading.
keep
We, the
running,
jury,
I
find the
guess, the
defendant,
audio
Darrell E.
because
Brooks,
Mike
guilty
didn't
of
do
first
jack
degree recklessly endangering
all
safety as
about
charged in
that.
count 62 of the information.
But
If
I'll
you find the
take
defendant
it.
guilty of first
I
degree
guess the best thing
recklessly
I can
endangering
do.
safety, answer the following question,
Let
yes
me
or
know.
no.
Well, yes.
Did the defendant commit
let's
first
do it
degree
as an
recklessly
AMA,
endangering
'cause
safety while using a
It's gonna
dangerous
keep
weapon?
repeating the same
Count
thing
63.
for
One
the
reading.
next
We, the
probably
jury,
hour
find
or
the
so.
defendant, Darrell E. Brooks,
So
not guilty
let
of
me know
first
what you
degree
want
recklessly
to
endangering
ask,
safety
and
as
I will
charged in
do my
count
best to
63
answer
of
as
the
long as it
information.
is within good
Another
taste.
reading. We, the
and
jury, find the defendant,
it
Darrell E.
is
Brooks,
not illegal.
guilty of first degree
So
recklessly endangering safety as charged in
that
count
is my
63 of
offer.
the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 64.
Let's
One
see.
reading.
First
We, the jury,
one.
find the defendant, Darrell
Matthew,
E. not guilty of first
go
degree
F
recklessly
yourself.
endangering safety as charged in count
That's my answer
64
to you.
of the information. Another reading. We, the jury, find the
JK,
defendant, Darrell E.
JK.
Brooks, guilty of first
Otherwise,
degree
that would
recklessly
be my
endangering
answer to you.
safety as charged in count 64 of the information.
Healing from surgery.
If you find the
Uriel,
defendant
I'm
guilty
so
of first
sorry to
degree
hear that.
recklessly
I
endangering
hope you're doing
safety,
well.
answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
What was it like hanging
Count
out with
65.
Ferris Bueller?
One reading. We, the jury,
was an
find the
absolute
defendant,
blast.
Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 65 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65
Thank you,
of the
Diane. I
information.
appreciate that.
If you find the defendant
Looking
guilty
for
of first
verdict
degree
tonight?
recklessly
Yeah, I am
endangering
as well.
safety, answer all of the
I need
answer
some
the following
actual real
question,
life
yes
stuff
or no.
to get done.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 66. One reading. We, the jury, find the
Oh, Lord.
defendant, Darrell E. Brooks, not
Hi,
guilty
Debbie.
of
It's
first
pleasure.
degree recklessly endangering safety as charged in count 66.
How long must
The
the jury
information.
take before coming back? There is actually no requirements. It's basically until a judge decides that it's a futile endeavor. Otherwise, there's
I'll just repeat
technically
count
no
66.
long in which
One reading.
there's
We, the
no
jury,
time
find the
under
defendant,
which
Darrell E. Brooks,
they have to be
not
in bed.
guilty of first degree recklessly endangering safety as charged in count 66 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 66
Thank you,
of the
Catherine.
information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
I'm
Did the
doing my
defendant
best, so if I
commit
miss
first
you,
degree
I
recklessly endangering
apologize.
safety while using a
But there's a
dangerous?
ton of questions coming in.
Count 67. One reading.
What is my
We, the
drink
jury,
of
find the
choice?
defendant,
Right
Darrell
now,
E. Brooks,
Arizona
not
Iced.
guilty of first degree recklessly endangering safety as charged in count 67 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks,
Now that
guilty
I'm in
of first
Florida,
degree
I glom
recklessly
onto
endangering
the Florida
safety as
collegiate
charged in
team.
count 67 of
honestly,
the information.
College
If
football
you
has
find the
never
defendant
really
guilty of
been
first degree
thing for
recklessly
me.
endangering safety, answer the
That's
following
just the
question,
reality,
yes or no.
and I
Did the defendant
apologize if you
commit
don't like
first
that
degree
answer.
recklessly endangering safety while using a dangerous weapon? Count 68. One
Am
reading,
I
we the jury
single?
find the defendant, Darrell E. Brooks,
Sort
not
of.
guilty
It's
of hit and
complicated.
run as charged in count 68 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in
Know how
count
an
68 of
appellant
the information.
lawyer deal with
If you find the
him?
defendant guilty of hit and run,
No, it
answer
would
the
be an
following
absolute
question,
nightmare. I
yes
wouldn't
or
take
no.
it
Did
if
the
somebody
accident
held a
cause
gun to my
death
head.
to Virginia Sorensen? Count 69. One
John, are
reading,
you
we the
outside?
jury
No, I
find
am
the
not.
defendant,
I'm in my
Darrell E.
office,
Brooks,
which
not
is
guilty of
my
hit and run
second
as
bedroom
charged
in my
in count
apartment.
69 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run
Can't
as
tell in the
charged in
chat to
count
go after
69 of the
themselves.
information.
LOL.
If you find the defendant guilty of hit and run, answer the
As long as
following
Mike
question,
doesn't
yes
care,
or no.
I don't care.
Did the accident cause death to Leanna Owen? Count 70. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count
You
70
definitely quote
of the
Austin
information.
3:16.
Another reading, we the
That's
jury
not actually
find
a
the
book of
defendant,
Bible.
Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information. If you find the
Everyone
defendant
follows
guilty of
John's
hit and
channel.
run, answer
I
the following
appreciate that.
question,
Thank
yes
you.
or no. Did the
You already talked about why the golden rule argument is disallowed. Yes, I did. I can do it briefly. Basically, the idea is it's prejudicial to suggest that the jury put themselves in the shoes of the defendant. Not because it's prejudicial to the defendant, but it's there is a confluence of moral issues that are associated. When Queen monetize your channel, we're getting there. I'm about a little over halfway there. So, if anyone would like to watch my stuff, it's Robine Law. I would love to have you. Let's see. Question: do you know Peter and the Trigos family? I do not. I've actually, you're not the first person that recommended him. I just don't personally know him or his family. They are obviously close to me geographically. But I don't want to go out of my way to bother people if I don't have a specific reason. Iced tea. So Mike71, I am licensed in New York and Florida. I'm currently living in the Tampa region of Florida. That was mostly because of COVID. They shut down the courts and, one thing leads to another. I can smoke inside? Yeah, I can smoke wherever the hell I want. It's my own freaking apartment. Let's see. God, I'm trying to scroll and you people keep posting comments way too quickly. Jen asked, I know you like to be more of a teacher, but have you thought about doing Florida Man stuff on your own? I've thought about it on my channel.
How dare you, Dax?
I prefer doing the educational stuff. Every now and again. I don't know. I am not anywhere near the end of Law Talk with John, Mike. But if you're back, then you are back. S looking. John, so many trials being, God almighty, record and stream. Do you think the appellate courts will start using them, start using videos instead of reading the record? No, I don't. Where did the music come from? That's Mike. You can blame him. It's his channel. I'm just occupying it for a minute. All right, I'm gonna scroll down, try and catch up a little bit. She done, co-host. All right, we might be done with this.
The court may ask each of you if you agree with the verdicts. Before I swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury during their deliberations and sequestration. Wait, hold on. Yeah, let's see.
Did anyone hear if she dismissed them for the day? I didn't hear that.
I have a lot of stuff up here. There we go. Counted and recounted 15. So we have placed each one of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be the alternates, who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror.
I think she's gonna have them deliberate tonight.
The first number that I'm pulling out is 10. The second number I am pulling out is 30. And the third number I am pulling out is 1. I want to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure.
I know you got other stuff going on, Mike, but agree with me if you can. I think she's having them deliberate tonight. Because she'd prefer to do that other than sequester alternates.
And I just confirmed that the other 12 numbers were in there. I'll put those back in and then we'll make a record of that. All right, then I will need all of the deputies and civilian bailiffs to come up and be sworn on the record for the sequestration. And
it's finally dawning on him that his time is up. That's literally what's occurring at this moment.
Clerk of Court Taz, why don't you join them just in case you're needed? All right, would you all please raise your right hand? Do you swear that you will keep all jurors on this trial together in some private and convenient place, and that you will not allow any person to speak to them or you speak to them yourself, except to ask whether they have agreed on their verdict, and that you will not, before they render their verdict, communicate to any person the state of their deliberations or the verdict they have agreed upon, so help you God.
Yeah, amen. Bravo, bailiffs. Can we
Madam Chair,
have
we'll just
some
let the record
claps in the
of who you
chat
are.
for the people that are actually
It will take us a moment just to have all the
facilitating
finalized
this process?
paperwork. to go
They don't
back
get
with
enough credit.
The jury. We do have all of the verdict forms, if I want to give that to Jen. All right, and here are the jury instructions as well. For the record, it's 6:24. All rise for the jury as they're excused to begin their deliberations.
Oh, you're toast. Yep, we made it to deliberation today.
But yeah, I'm gonna need all of them and then I'll
Yeah,
take
no, I
them
know,
down and all
but
that
those are
stuff.
the-
Yeah.
That might not take all of this evening. I suppose we shall see.
Is that closed? No. All right, thank you. You may be seated. Just so the record is clear, the alternates, of course, will not be participating in the deliberations. They will be in a separate jury deliberation room and will only be called upon if needed, of course, after consultation with the parties. As far as how late, I will let them deliberate tonight. We have ordered dinner for them. I believe it will be here shortly. And I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening. They are under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home.
Oh, they took their phones. This verdict's coming back tonight.
Discharged from the court.
This
whichever
verdict's
order
coming back
sooner.
tonight.
No one wants to spend the night without their
Anything,
phone.
Else
In a
the parties would
cheesy
want me to
motel?
address at
God,
this
no.
moment
Yeah.
from the state? Anything from you, sir?
Yep.
They already got dinner.
So essentially, I would have to stay here while they're delivering. I'm gonna be able to go back to my unit, use the phone, shower.
No.
It is shower day for my pods. I want to get 2 shower days.
I
a
don't,
week.
so here's what could happen though, sir. I don't have a problem with you doing that, but they could have questions. And then you would need to become available so we could address any questions. They may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits, some exhibits initially. I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well. Okay.
And one
I
more
mean,
thing.
what?
Go ahead.
I was
Absolutely.
I was curious. 61 charges for the reckless. 61 injured parties did not testify. So how does that work? How essentially how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir.
Damn it,
the
we got to
state,
suit up.
presented their
6:21. We
theory
still
of the
got to suit up.
case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And I guess that's all I can really say about it at this
That's not
point.
a proper rule.
I got a point though.
I'm sorry?
No.
I got a point though.
No, you don't.
No, you don't.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof, and they have to convince a jury beyond a reasonable doubt.
It'd be nice to see him go away.
For better or for worse, sir, I was not presented with any motions to
it.
dismiss, either at the end of the state's case or the close of the evidence, regarding any legal arguments you may have had regarding those issues.
Nothing exciting.
And so at this point,
I either had to order or actually cook.
the jury has the
That's
case.
why I had to
and they
go because
will
I'm starving.
determine their verdicts. If there
I
are
cooked.
issues of law that you want to raise after the verdicts are received,
I was
then
going to
you'll
go
have
get
to
some
make that
dinner,
determination.
but
Yeah, that
when
has to be
she actually
raised
released the
because
jurors,
essentially you can't. If no inter-party
gotta stay
testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in front of me based in law or fact. So for me to comment any further would require
And
me
your
to give
theory
an
sucks.
advisory opinion, which I'm not willing to do.
So you saying I need to make a motion?
So
That's
what I
like-
will
You
say
have no
at this
theory.
point is I do have one
You have
issue
no
that I would
theory
like
of
to
law or
raise with the
fact.
parties.
That shit is over.
I frankly would I need a break a little bit. I mean, obviously the court
That
has
ship
to
has
stay
sailed.
open. I know my dinner is coming. And
it's
I
more
think
than
it's
sailed. It's fallen
reasonable
off the face of the earth.
together, but I
under a
do need
flat
to
earth
make a record
theory.
of some information that I received earlier today, so that the parties are advised of that. But I will do that.
Okay, I'm hanging tight.
Let
This
me
verdict's
confer
coming
with the
back.
sheriff's department about
Next hour or
your
two.
request.
This is going to happen.
I think
I'd
it
like
will.
to take in about 30 minutes, address the issues that I need to address, or the issue.
I think they're going to have their dinner,
And
and I
I
think that
want
they're
to
going
find
to
out if
check all the
that
freaking
would interfere
boxes,
with your
and we'll be
request
done with
about
this.
taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the sheriff's department and have a more definitive answer for you shortly. Okay.
Can I get my filings?
You want
Goddamn right.
you want the
Like,
original.
where's he going to keep them?
If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back.
Does he have a
The
locker or
date stamp.
something for this shit?
They
He's in
don't
a
have
cell.
time because they were filed in court.
I have some ideas, but they would not be appropriate for polite conversation.
Printed them after I scanned them in, so it has a document.
All right.
So you're getting
Well,
the two
I'll be
copies.
popping in. I'm going to keep this on the
Okay.
background.
See, I didn't interrupt you. See,
I'm sorry.
I said, see, I didn't
All
interrupt
right,
you.
welcome to
Thank
Law
you. I
Talk with
appreciate
John.
that. Unless I would like the parties back in about a half an hour. Thank you. Unless they have a question sooner.
Your Honor, do I have to go in that holding cell or do I got get to go?
I have a strong suggestion on where we can hold you. All right, I'm gonna do this as Law Talk with John. So, anybody that wants to ask a question, I'll do it like an AMA. Original trilogy or prequels? Original trilogy, not even a question. And I'm gonna keep up as best I can with the questions provided. He's going to pay-per-view chain? Yeah, probably. Who's my favorite Darrell Brooks witness? Probably the detective. He was fantastic. Does the jury or judge determine sentence? Ultimately, it's going to be the judge. The jury determines guilt. The judge ultimately determines the sentence. That is in every jurisdiction I'm aware of, but like I always say, your mileage may vary. Is it true that... Where did that go? Tips for a current 1L? honestly, keep your head down, stick to your books, figure out what your professor is looking for. Presume that you're a judge, because ultimately they're going to be the one that judges you, and you don't get a retry at it. John, do you know you are respected? Well, have to agree with Mike. You have dinner coming, blah, blah, blah. I appreciate that, Big Bun. Thank you so much. It's very kind of you. Question. What will 70 plus injured parties do to change things as surely as 6 dead? As a practical matter, it won't necessarily. However, the 6 dead is more than enough to put him away for the rest of his life. And so at that point, who cares? If you have 6 consecutive life sentences, to some extent, I don't actually care what the rest of your sentences are. And that's kind of where we're coming at here. Let's see. Even if he's not found guilty, oh God, this keeps moving. Even if he's not found guilty on charges, no, don't have it. And I'm not dealing with the freaking trolls, so you can all go screw yourselves. Question, wrongful death suit? Probably, but he doesn't have any money. So what are you gonna recover? There's probably a case there. But yeah, like I said, if he doesn't have any money, probably screwed anyway. There's nothing to collect from. Did I hear the jury was taking a 30-minute break too? No, but that's okay. Everyone's entitled to dinner. I would like to do it myself. Instead, I'm spending it with you all. That's what Mike's doing. John, my daughter wants to study constitutional law. Thoughts? Terrible idea. Don't do it. Who wants to be a Leo? Me, John? If you consider a defense or prosecuting attorney a Leo, then yes, I actually would like to do that. If you want me to be on the beat, God bless you. You have all my respect in the world. I would not personally want to do it. Can we put John in charge? You'd probably have to fight Mike on that one. Why do you think they only charged him with 2 counts of hit and run and not 60? Who are we referring to? John, how long after sentencing does the appeal process take? Very much depends upon jurisdiction. In Florida, very, very quick. In Wisconsin, I honestly do not know. Usually, your period to appeal, at least in most of the jurisdictions that I've worked in, it's about 60 days to appeal. Otherwise, you forfeit it. So I don't know if that's the case in Wisconsin, but that is my general understanding of how it operates in the jurisdictions under which I practiced. John, The question I wanted to ask, but forgot, his mom not showing up. Was it a subpoena? And if so, what ramification is there for failing to turn up? I think they never served the subpoena. I think he never served the subpoena, him specifically. In the previous phase of the trial, the state went out of their way to provide a courtesy to provide service on his behalf to help him. He did not take them up on that in a timely manner, and they didn't have to do so any further. So I believe that it was never served, and so there is no actual consequence to his mother. John, you'd be a great researcher for a judge on the bench. I think you would really enjoy it too. Yeah, I like research. I always said that. I was always a fan of that. It was fun. I enjoy teaching more than I enjoy practicing in a lot of cases. But I enjoy both. I'm trying to keep up as best as I can. John, can he be found guilty of lesser charges, even if they can't argue them? I can't imagine a lesser charge that they can't argue. So, yeah, as a matter of practical law, the answer is no, but I don't think that's relevant here. Kendra, I don't care. Is the jury out now or what? Yes, the jury is out at the moment. They are deliberating. I think that there is a halfway decent chance that they get back, but we shall see. Kona's mom, I appreciate that, but I'm gonna stick around until Mike gets back. I'm not gonna leave you all in the ether. Hey Ben, how are you?
I'm all right.
Welcome to Law Talk with John. I'm basically just answering chess questions until Mike gets back. The jury's out deliberating.
Oh, sounds like fun.
Yeah, it is.
So what you got, man? What knowledge are you dropping on everybody now?
As much as I possibly can, within fair bounds. I don't have the ability to pull them up on the stream, so I'm doing the best I can just to read them and answer. But it keeps running by me because every time I try to read them, new people comment and it just runs up.
Oh, someone. Oh, Ruby goes to the groomer tomorrow morning. I didn't see who asked that.
All right, that's not so bad.
There you go. Hi, Queen stepped on a bee. How are you? But what's my guess on when they come back? I think it's going to be a quick verdict. I was thinking that we could be done tonight.
I'm genuinely thinking it might come back tonight.
I think the jurors want to be done. You know, they want to. This has gone on for 3 weeks for them. They've had to think about it. They can't talk about it, you know, if they really are serious about their oath. It's just got to be draining on them, and
it's got to be. And they already had the sequester motion approved, so they either come back tonight or they have to go to some crappy motel without their phones for an evening.
I mean, I don't know. Do you think? I mean, I can't even see how there could be, because I mean, he had no defense. There was no vigorous defense, no plausible argument to even for the jurors to discuss. I mean, I can't imagine there's anyone that would hold it up. I just got to think that they're all like, "Yep, this guy's guilty."
I genuinely do not know. I mean, I was telling the chat that the record is 9 minutes to come back. I don't know that we're going to get that here, obviously.
You ready, Ben?
I'm ready, man.
Let's see what happened here, brother.
Oh, we going to Kim? All right.
So this is Kim's big court appearance from today. I have not seen it. I don't know what's going on. I've got Kim's former attorney Ben Bateman here.
I've seen about the first 3 minutes of it. Sorry to talk over you. And you do see Kim in his
criminal defense
CCDC
attorney,
blue
thirst trap. You know, Ben Bateman. He's gonna
Oh,
go
that
over
guy.
this with me. We're gonna straighten this thing out.
All right.
Wait, let me find it. Where is that one?
And I just want to ask something else, because you've not been allowed to withdraw from the Supreme Court.
So they said there is no conflict of interest, and I would agree with them. There's no conflict of interest.
Wait, it's just quiet. I'm just turning up the volume.
We have a conflict.
Right, but they denied your motion. So I'm just trying to figure out how you could stay on, because if you stay on the Supreme Court.
Look at the smile on Ben.
Well, Your Honor, again, I believe they misread my motion when it was filed. We would.
Good luck with that one.
Well,
I mean, you know what I mean?
Oh, dear.
Oh, does it look familiar, Ben?
Please
It does. You know, I went and said hi. Stopped by and said hi to Joe this
Ready to
morning.
go?
Good luck. I said hi to Alex and Brittany.
State versus Blandino, C341767. He is present. He is in custody, and this is on for a revocation hearing. The state can make their appearance.
Mike Dickerson of the Athens State, Your Honor, bar number 134.
Yes, gives me flashbacks.
Point, Your Honor, Joseph Gerson 13876.
Triggers my
Okay.
PTSD.
I did see your motion. I'm not gonna allow you to withdraw because I don't think that the issues that you raised are specific to you. That's what Mr. Blandino does. And if he, let me finish.
Yes, right.
And if he chooses not to talk
He
to
sure
you,
does.
he does that at his own peril.
Judge, no, he hung up on me. He's refusing to communicate with me, Judge. He hung up, I got witnesses at the CCDC that he hung up on me, said, I'm not gonna be insulted. I was not insulting him.
Well,
I was respectfully
people
telling
don't
him the
have to
truth.
stay on the phone if they're being insulted.
I wasn't insulting him.
Okay, well.
I presume not
he
guilty of
believed
that.
you were insulting him.
Your Honor, as I mentioned in my motion, I do have some issues that I don't believe are appropriate for open court.
Can I just pause it 1 second?
I would like to talk to the court in a
If you
closed
will.
session. There are some really.
I've been there where I've had to hang up on him because he won't stop talking. Okay.
Yeah,
I
Here's the
believe
thing.
you.
And he doesn't. He's got the idea that if you don't agree with him, it's because you don't understand, and so he won't stop talking. So I believe that Joe has probably had to hang up on him. I would not doubt it at all. Because it's just like when you say if you counter with, well, what about this? He's like, no, you don't understand. If you only understood, then you would be in complete agreement with him.
Ben,
I've been there where I've had to hang up. It's just crazy.
He was talking to me about this from jail. He was saying, "Oh, he hung up on me. He hung up on me." And in the first 10 seconds, it sounds like it's a little different than he reported. I mean,
Dear.
like maybe he hung up on him, but after like you said, like he had no choice, kind of a scenario.
Like, I'll give you an example. I had a
Client that was not mine. It was part of my firm, but wrapped his member with anesthetizing agents. Was an MMA fighter, got into a freaking fight over the whole thing, and then decided that he would tell in writing his attorney that he would rip off his head and relieve himself through the neck hole. It's like, okay, at some point you really do need to actually relieve the attorney.
Oh my!
Wow.
Kim's better than that.
Yeah.
Kim will
Kim's
just
never
go
gonna
on and
do
on
that.
about his misinterpretation of law until the cows come home.
Right. And I
There are no threats.
just love it. His yes, and I have witnesses at the CCDC that
Yeah, Levitt's.
that he hung
she's
up
like,
on me.
I know you, brother. I have been through it. She's skeptical of anything Kim says at this point.
We've all had ludicrous clients.
All right, you can keep going here.
I can guarantee you they're not unique to you. That's what he does
I'm
because he
pretty
wants
sure-
to
I
represent
object to that's
himself.
what he does.
I
I
mean,
object to
you
that.
Look at the record. I mean,
Your
I
Honor,
knew you would file a motion shortly. I knew it.
No,
It was a matter of time.
Well, Your Honor, I'm pretty sure some of the issues I have are unique. And I think that if you heard them, you would find them to be pretty awful.
Why didn't you file an affidavit?
Well, again, Your Honor, these just happened last week. There's a whole history here, Your Honor. But they just happened last week. I got in the motion as fast as I could because of this coming hearing right now. So again, I would, Your Honor, just for completeness, you know how Mr. Blandino is. I would like to at least be able to present them to you. If you still think it's not appropriate, then fine. I would just like to make a complete record with you if I could, so that, because as you know, that's what Mr. Blandino does, is he just, goes on a record. So that is my request, Your Honor.
He wants you to withdraw.
No, and I understand this. I've spoken with Mr. Christensen about this. He has a plan in place, I believe. Again, I'd like to explain that to you, and I guess it would be in an ex parte.
Well, if you want, then you can file an affidavit or order it sealed and it'll be made part of the record.
Judge, if I may?
No, you may not.
I object.
Your objections.
Awesome.
All right, your objection is noted. Nobody cares.
Are you muted? Is Mike muted?
No, maybe.
Oh. Can't hear you, Mike.
Why is Kim not sitting at the table, Ben?
Just because this is it's not necessary for him to be there.
Is that what they do when they bring him in from custody? It looks like there's other guys in custody. I'm not sure.
Yeah, generally speaking, on motion hearings like this, it's not necessary. Sometimes I'll go and stand in the jury box next to them, but usually a lot of times they don't because they're chained in pairs. It looks like he's by himself, or he might. I don't know if I can't see how close he's sitting to that guy next to him. He's either chained to that guy next to him, or so usually in pairs like that, they don't bring him over for a motion hearing. Now, if it was a preliminary hearing or something like that, or you can ask to have him brought over there. So, but usually,
oh my God,
on
but
this, it's not done that way. Where he comes.
He did the same thing that Brooks has been doing, and he's done this all along. So they share that, where judge makes a ruling and he objects to the ruling. It's like, no, it doesn't work like that.
Yes.
You know, after the ruling, you lost.
I need
That's
to give
how
him
it
the
works.
list. Will you reconsider? And then will you do, what was this? Reconsider, finding of fact and conclusion of law, interlocutory appeal. He needs that list to go through.
Oh God.
Savannah,
But, and it is more. I mean, it's frustrating from Kim, but again, he doesn't have a body count. That's a big difference.
Yeah.
He's no angel, but he doesn't have a body count.
can I break in for 1 second?
Go ahead.
Savannah asked if I was going to cover the Anthony case as it relates to the Brooks matter. I did that the other night. You can find it on my channel. It's under the Allen explanation. Mike and Natalie Wisco were on for that. So it was really a cool conversation. So go check that out.
That was yesterday, I think, wasn't it?
Yeah, that was yesterday.
I don't know. I'm losing my mind.
It was either yesterday or Sunday, but everything's been
it was a fun stream
together.
Thank you.
Well, then, okay. I mean, again, I would object, but I understand where you're coming from. I've been dealing with Mr. Blandino, I get it. I know
You
that
object to what?
you won't let me withdraw
At this point.
or present this information to you.
Oh, no, I'll let you present it, but you need to prepare an affidavit.
And again, Your Honor, I have a real concern about what I'm going to be presenting. But that's fine, Your Honor. I will.
You have a concern about putting it in writing?
Yes, Your Honor. Exactly.
What would be the difference? Because if you told me there would be a transcript.
Sure.
Do you see my point?
I do.
You know,
Dickerson's
even if
like,
I
I'm still here.
excused, you know, the state, I still
Well,
would
again, Your
have.
Honor,
I can't get rid of the case like Ben.
Maybe Your Honor would,
Oh, man.
in a sidebar, listen to what I have to say, and then make a determination if it's necessary to do all that or not. That's what I'm asking for. If that doesn't work for Your Honor, fine.
I'd rather have it in
Sure.
an affidavit.
Sure. One of the other issues, Your Honor, is, and I have been, one of our witnesses, Mr. Eric Chandler, Officer Chandler, I know he contacted Chambers. We have him subpoenaed here for today. He cannot be here today. And because he does the parole board revocations, I know he communicated that to your staff. He communicated it to me out of professional courtesy. I released him from the subpoena because he wasn't going to be here. He couldn't be here. He had asked me to respond to you that Thursday, he does that every Tuesday. So he's available on Thursdays. That's that. And again, Your Honor, we don't have a written response because of what happened last week with Mr. Blandino and I. Because there's also a motion to impose sentence. And that's what I thought was on, not the revocation, the motion to impose sentence.
Thanks, Cheesehead.
So,
In my opinion, it's the same thing.
well, the only reason I bring it up
Father
again
there.
is Mr. Dickerson made a real distinct point in his motion to impose sentence that it was something different. So again, just so I can make the record on that, and again, I was ill last week. Mr. Blandino acted up on me. We stopped communicating 100%. So I was not able to, put together the motion. I was hoping for my motion to withdraw.
I'm sorry, he stopped 100%, Judge. I object to that characterization.
All right.
I'm willing to talk with him right now.
He objects to his own
Sit down
attorney.
here and I will communicate.
He
as
objected
much
to
as
his
he
own
wants me to
competency.
communicate.
Is that it?
Is this an ad? Ben, I swear to
Come
God,
back Thursday. I mean, I'm trying to get this
it's
done
been
as
too
soon as
long a
possible,
day.
especially since Mr. Blandino's already been in custody a couple weeks.
Judge, may I?
No,
I'm available Thursday if you need me, Your Honor.
Mr. Dickerson, I don't know, do you have witnesses that are here?
I do have two witnesses that are here, Your Honor.
Are they outside or are they here?
One's right here in the courtroom, the other one's outside.
Do you want to check to make sure that's
Yeah,
okay?
I can see.
Oh my
It'll be
God.
10:30, Mr. Dickerson.
10:30?
10:30, if you want to tell the witness.
Okay, and then my only issue with Thursday in that regard would be that, you know what, I think I'm gonna be okay at that time. Yeah.
Thursday at 10:30.
Wait, we pulled it a week?
Judge, may I sit down?
Sure, of course.
Thank you.
Yes, Your Honor, that would
How
work.
do you think the state of the case is going to change in a
I
week?
just want to ask something else, because you have not been allowed to
Well-
withdraw from the Supreme Court.
I believe there was I had filed a motion of an irreparable conflict. The Supreme Court read that as a conflict of interest, Your Honor. So they said there is no conflict of interest, and I would agree with them, there's no conflict of interest. We have a conflict.
Right, but they denied your motion. So I'm just trying to figure out how you could stay on, because if you stay on the Supreme Court, sorry, you're staying on this one.
Well, Your Honor, again, I believe they misread my motion when it was filed.
Poor guy.
Misread his motion.
Well,
I mean, you know what I mean?
I mean, I understand what you're saying, but it was clearly misread. So, we were going to file a motion for limited remand to you so that potentially you could replace me on both this and the.
She won't do it. You won't get that, and she won't do it.
Well, you're F.
Your motion withdrawn, and if you want them
Based
to
on an irreparable
reconsider-
conflict of interest.
Joe,
not
buddy.
a conflict,
No, he's not entitled to
I'm screwed
bond.
on this one, my friend.
And that's what
He's
it
not
was.
entitled
I mean,
to
if you read it closely, that's what it says. And again, Your Honor, Mr. Blandino has continued on with other activities that are making this very, very difficult from a philosophical, religious, professional, et cetera,
What's the
way
religious?
to represent him. So I understand the history of this case, and I think it's taken a little bit of a left turn. As I said, I've been discussing it with Mr.
Ain't none of the left turns on this one.
But whatever you'd like me to do, Your Honor, I mean, I'm
It's gonna be the same problem
so.
with whoever is appointed. Because, you know, he doesn't like that the court revoked his ability to represent himself. So, and quite frankly, it went on probably too long. So we're gonna continue it to Thursday at 10:30. And if you can.
I got it. I'll
submit
never be in
your,
front of her, so I don't
affidavit
care.
in
But
chambers.
she has the voice.
Right, and I will order it sealed, so if you'll, also prepare an order. It'll be marked and made part of the record, but it will be sealed.
Thank you, Your Honor.
Can I get a copy of that, Judge?
I'll make that determination after I see it.
Thank you, Your Honor.
Thank you.
Thank you so much. I appreciate that.
Thank
Thank
you.
you, Your Honor. Thank you, Your Honor.
Wow.
Oh,
Yeah.
good Lord. Shout out to
So,
our buddy
it looks
Alex
like-
at our Nevada Judges for putting that together for us.
Yes, like and subscribe. So it sounds like they didn't have their witness available today.
They had two witnesses, but yeah, they had that. He has that one probation officer that's helpful to him, and he wasn't there.
I mean, they had a witness that would be helpful to his case,
Yeah.
presumably himself. But
I feel bad for him, and his attorney knows it. He can get out of this. The traffic court attorney didn't care. If he signed the thing, Judge Levitt would violate him, sentence him to time served, and let him out.
Yeah,
And he,
But
that
I
could
don't
happen
know what
today,
this.
but he will not cooperate with his attorneys, and now we're in this spiral of him getting out. Levitt basically told him, "You're not getting out." He's like, "Oh well, the Supreme Court messed it up, and I'm filing another motion for them to remand it back to you." And she's like, "Okay, great, but when it comes back to me, you're still not getting out."
So yeah, I don't know what because he was appointed for his appeal. You know, Joe does the appellate work, and now he's stuck doing traffic trials and whatever else. And
His biggest issue is that probation violation / failure to sign, however you want to characterize that.
Right, and I don't know if he tried to withdraw from the Supreme Court. That's what it sounded like. I don't know. I'll have to follow up. It sounded like he tried to withdraw from the Supreme Court.
Yeah, and he probably called it with them because that's what you do on an appellate matter, I would guess. I don't know. That's probably the procedure in Nevada.
I don't know what the procedure is, but it seems like this is a case that's below him at this stage of the game. And
I'm sure
he doesn't want to
Jim
be
is
a
telling him
free
all the
record.
motions all the motions that he wants him to file, all the things I can just imagine. And he's like, no, these are not, these are meritless. These are, I cannot do this. So I'm curious what these other issues are.
Oh, the poor
I mean,
guy. He's in. I mean, he got in on the appeal, and he is in all the way.
Yeah.
I mean, he argued in front of the traffic judge, or whatever I call him, the traffic judge, but it's not. What do you call it?
Justice of the peace, justice court. Yeah.
Justice court. So in front of the justice court judge, who was cool, he argued for Kim to have his right for self-representation back. He did.
Right.
He was hoping for it.
That would have been. I mean, but that would have been a nightmare, though. Could you imagine standby counsel for someone in jail? I mean, like we went over last time. He standby counsel for him on his traffic trial, and then lead counsel on his probation violation for the traffic stuff. It's
Well, Ben, when we're talking about it, as it related to the Darrell Brooks case, could you imagine trying to appoint somebody to be standby counsel at this stage of the litigation? No, of course not. It would be an absolute torture.
Oh, but you got to go through my playlist, John, and see. We had Kim file a motion to get rid of Ben. We had Ben file multiple motions to withdraw from representation. Judge Levitt was having none of it.
Yeah, I mean that kind of. Well, when we had a meeting, and I finally had it where I just told him, look, I am not using your theory of defense. We are doing things my way now that I got appointed, and we're not doing your thing. And so then he started sending letters to everyone about how he needed his self-representation back, how I was just terrible. And so when he started doing that,
Mike, it looks like the court's back, by the way.
Oh, let me go. I'm gonna go grab that.
Was sent. The email was received by the clerk of court at 9:10 a.m. Then my clerk received a notification at 9:30 a.m. that the clerk of court wanted to speak with me. You may recall this morning I stepped off the bench for a little bit of time. I read through the information that was provided to me, which was an email, and then the attachment, which is a color print off. Looks like the person took a screenshot, in that the anonymous post claimed to be a member of the jury on the case, and here are my thoughts on the trial and on this subreddit. And apparently, again, it's a subreddit called Justice for Darrell. All those Justice, the number 4, and Darrell all. No.
I highly doubt any of this.
None of this is true.
Had contact with Captain Dussault, advised him that this should be investigated, and basically turned over the matter to law enforcement for a full investigation.
I really am not
I
buying
made a
this.
determination based upon my review of the information that I would not stop what was happening in terms of the trial with the instructions to the jury and ultimately the closing arguments, and then turning the case over to the jury for deliberations. And of course,
I don't know. I
am
haven't seen
concerned
Justice
about
for
the
Darrell
integrity
as a
of these
major
proceedings, and I will
hashtag
take
on
whatever
Twitter.
action that I deem appropriate once a full investigation is done. But at this point, there is no, I would say, credible information that this is in fact a member of the jury. But I will
Probably
leave that
not.
for law enforcement to determine. And if, of course, if need be, at the conclusion of the case, when the jury reaches a
But it
verdict,
muddies the water.
I certainly will consider whether any questioning of the jurors at that point is warranted. So that's the information I wanted to provide. Again, copies of this information will be provided to the parties, and there is a full investigation underway by the Sheriff's Department. I have no further information about it at this time. I will not be the judge that will further be reviewing it in terms of any requests related to that investigation. I will simply be handling whether any requests as it relates to this case in particular.
This case just keeps getting weirder.
For the parties.
Wow.
Doesn't
And
stop.
provide those. Go ahead.
I'm making sure you was
Go ahead.
first. What is this?
All I can tell you, sir, is that there is apparently on the internet, on a site, or maybe it's an application, I'm not entirely sure, called Reddit. There's a subreddit that is entitled Justice for Darrell, and it was on that subreddit that someone wrote an anonymous post claiming to be one of the jurors.
Lord.
That, of course, would be a violation of the rules that I set up for the jurors, which is why I turned over the information to law enforcement so they could make a full and complete investigation.
That's one thing that irritates me.
Except for value,
Is this.
for value these documents. I'm
Yeah.
confused.
You're confused,
At this
you're
point, sir, I'm
guilty, you're an
providing the
a-hole, I
information.
don't care.
I trust that the parties will review it, and if a party believes that any request needs to be made of this court, then an appropriate request will be made. But at this point, I'm just advising the parties of the information that I have. And I will add this, I will, of course, it's important that the results of any investigation be turned over to the parties. I don't know how long that will take, but that is also my direction. That was really the only direction I gave to law enforcement, is that the results of the investigation that be turned over to the parties.
Was this? Oh, I'm sorry.
Go ahead.
Was this just found out about this morning?
Yes, the email that was sent to the clerk of court was received at 9:10 a.m. And then that email and the attachment, I'm aware of a second, I will say I'm aware of a second email that was sent to our clerk of court at 10:02 a.m. And I think when we stepped off.
That's actually a legitimate
Then,
radio.
following the case being given to the jury, I was advised that other emails had been received throughout the court system. And I simply said, obviously, that information needs to go to law enforcement. I haven't seen it, haven't reviewed it. But any person who works in the clerk of court's office who has received an email that email about this topic will be forwarded to the Sheriff's Department. Their forensic unit is handling the investigation, to my understanding.
This is a legitimate Brady issue.
Attorney Hopper, did you have a question or something to state?
Yes, Your Honor, I just wanted to state for the record that I have also received similar emails at my office this afternoon. They were sent not to me directly, but to the district attorney's office website. And I only wanted to point out that in viewing the contents of the posting, well, first of all the emails refer to the exact same posting and the language is the exact same in all the postings. In viewing the contents of the posting, we question the veracity of the posting because it refers to things that, quite frankly, are not true. And also, upon reviewing it, Your Honor, we came to the conclusion that it does not exhibit any material prejudice against Darrell Brooks that may affect the veracity of any verdict that may be returned in this case. The posting is largely critical of the court and
Thank you,
to
Jordan.
some extent the prosecution, but the nature of the posting is actually in support of Mr. Brooks. That's why it's under a subreddit called Justice for Darrell. And I don't believe there's any reasonable reading of this post that would lead someone to believe that it suggests the juror harbors substantial or material prejudice against the defendant.
We don't know that it's actually a
Thank you. I
juror.
appreciate
Why-
the additional
Almost
record.
admitted that.
Can I say something, Your Honor?
Go ahead.
Yeah, I don't believe this is a juror for 1 second. I mean, I don't know, but I just don't.
Skimming through it.
I don't either.
No, it's not a juror.
I do want to state for the record that I have
You're
no
operating
involvement
on
with
the
this.
premise that it might be.
Really like shocked like this even came to light.
He's so excited. He probably did it
I
too,
will
but who
say-
knows?
Does he get a laptop in prison?
Just by skimming through it, these are definitely things that have been talked about in the court. So common sense would say that this came from someone that has either been in the court to hear what goes on in the court or a jury member. It's no other way.
Or
Well,
anybody
actually,
who
the proceedings
No,
are
somebody
by-
of the millions of
I
people
swear to
that sit
God.
in law and crime and law talk with.
So I don't agree with that assessment.
So Law Talk with Mike has 70,000
Well-
subscribers. Thank you.
I mean, it's pretty
If it
obvious.
comes
that
back
this
to
is
you,
coming
I
from somebody
swear to
who's
God,
actually-
I want them to
Guarantee
bring
my-
back the death penalty.
I guarantee my viewers
Seems
did
pretty
not
clear.
post something pro,
Well, I am leaving it in the hands of law enforcement to do a full and complete investigation.
Except as a
and
joke.
I take the integrity of this process incredibly seriously. And if there were to be a juror who violated the rules, I would take that very seriously, and I will not hesitate to take any action that I deem appropriate. At this time, it is simply being investigated. This was an anonymous post.
Yeah, it was me,
And,
guys. Sorry.
If
My bad.
either party believes any further action needs to take place as it relates to this particular jury, then I trust they'll file the appropriate request with the court. So with that,
Could I-
the courtroom, oh, go ahead. I'm sorry. Something else, Attorney
A
Alpert?
different topic, Your Honor.
Oh,
if
sure, go
possible.
ahead.
While we're all together, I just
Thank
wanted
you.
to address exhibits and what the court's procedure would be. We have no objection to any exhibits going back to the jury room if they are asked for, and precluding the requirement that we all assemble every time a note comes out asking for one exhibit. So as long as we're all here and we have some time, maybe we could discuss that.
I'm willing to discuss that.
We're not going to
You
get
have
his
any
verdict
position on
tonight.
that, sir?
He's
Yeah,
not going to grade anything.
I would object from the standpoint that
Of course he is.
You're a flaming
I would
asshole.
need
Yeah,
to
trying to
see
see-
the exhibit that's being asked about and the relevancy of that exhibit being asked for. I think that's only
Well, the
fair.
relevancy has already been.
Exhibits
with
that
when
are,
they
that
admitted
have
the
been
exhibit.
received, a relevance objection would no longer be
They've
valid.
already
because
received
The court has
my-
already ruled on the relevance and the admission of the exhibits. The issue is whether it goes back to the jury room. I'll give you for example. Sometimes in a trial, there are medical records that need to be filed in their complete form under the statute.
Oh, good Lord. He
Really,
won't
maybe only a
understand or
portion
care.
Of it would go
He
back
has
to the
no
jury.
idea what you mean.
Or
I know exactly
depending
what
on
you
why
said.
they were offered and whether there was any medical
I did
testimony
Med-Mal
regarding
for
a
2.5
diagnosis,
years.
for example, could impact that. Sometimes there's privacy issues with an exhibit, if there's a social security number for a witness or something like that. But generally speaking, the exhibits have been received, and the jurors can ask to view photographs, written documents. They can even ask to view the videos. The videos would need to be done one of two ways, either which requires everyone to assemble because we do have the technology to play them directly to the jury room. But that simultaneous with that is it would be played in here. So everyone would be seeing what's being played in the jury room at the same time. So that does require the parties to be in court. That allows the jury to continue with their deliberations, talk about what they're seeing, etc.
So can the jury see in here now?
No. I'm talking about a
Ooh,
video.
that's interesting.
We have the ability to play it directly. There's a TV. I should have said that. Probably not. Why would you know there's a TV in the jury room, right? So there's a TV monitor in the jury room that is connected to the technology in the courtroom.
They don't need no
whatever is
stinking
playing
exhibits.
Here could be a still photograph, could be a document, could be a video. We can play in the jury room at the same time.
They're signing the guilty forms right now.
But as far
As we
as
speak.
other exhibits,
God, I would hope so.
So it would be only the exhibits that's been
Yeah,
received.
you keep
So nothing
barking,
new,
little
nothing's gonna
doggy.
come out of the
'cause
blue
that
and be
guilty's
like, oh
coming
yeah,
back.
we're gonna.
only what's been received
Oh.
during the
All right,
trial.
Mike,
If it
we
would be
finally got
helpful,
to my
I can have
point.
Madam Clerk give you the
I'm
printout
being
of the
pissed
exhibit
off
list
at this
that shows
idiot.
everything that's been received, if you would like.
That's about like 7,500.
There's a lot of exhibits,
That's a
but
lot of exhibits.
but I'm willing to have her print it off if you would like it.
I think it'd be helpful just in case. I'm guessing at some point that will come into play.
For example, they may come back and say, we'd
drag
like
your
to see
feet on
exhibit
that, 'cause it ain't
15, which
happening.
is the map.
How about go
the
to hell?
Map from the parade route, okay?
At some point, nothing's coming into
They might
play
want to see
because
the other
tonight
map. Maybe they
you're
want to look at a
signing
video.
your death warrant.
There's a lot of exhibits, so I'm not going to speculate what they want. Sometimes they write notes to us and say they literally list out all the exhibits that they want. Other times they'll say, can we have all the exhibits? So sometimes parties do stipulate.
And
That's
by
what
the
the
way,
state,
if
I
they
think,
don't
is trying
sign
to
their
get
death
at.
warrant tonight, they're doing it first thing in the morning.
So do you have a position on that?
No, not literally.
If the
I know
jury
that.
requests an exhibit, do you want the court
I
to
wish
rule on
it-
it individually?
Sometimes I wish it
or
were otherwise.
do you agree that if they request an exhibit, it can be released to them?
A rule on it.
All right, fair enough.
It's going to object it. It's
Of course.
devastating
Else
to
to
my
the operator?
case.
Yes, we had discussed yesterday, and I'm not trying to get too far ahead of myself here, but
I could see him doing it though. He's a
what was the
perfect
time
Reddit
limit that
candidate.
the court wanted
Reddit
to,
is full of
work
guys
off
like
of
him.
for, giving notice to the parties
Yeah.
when the verdict is available.
You're not
30
wrong.
to
But if
60
he-
minutes.
Okay.
How would he get the word out? Those jail calls are
Some of that will
recorded,
depend on when it
monitored.
is, if it's
Did they give him
late in the
research
evening
laptop
versus during
and
the day.
maybe he was able to connect to the internet?
And you might be wondering, how late will I let
You freeze?
Why did
Yeah,
I?
we're done for the
Right,
evening.
okay.
They'll come back in. I'll read them the instruction about, they obviously can't deliberate when they're not here, so I'll read through that instruction to them that you can't deliberate. And
Oh
they would
God!
go again
We have to deal
where
with
they're
tomorrow.
being sequestered, and then we would reassemble tomorrow morning if that's what is needed.
Okay.
No, no, no,
Thank you.
no,
You're
no.
welcome. Anything else? from you,
Oh
sir?
man, is she releasing the jury?
Yeah, did you talk to the jail, the deputies? Or
I
whoever
did.
need
Thank
to
you for
talk
that reminder. The jail has asked that I follow the standard operating
I reminded them to
procedure,
punch
which
you in the
is to
face
have
when you
you
get back
in
there.
central holding and not up at your cell. But if need be, I'm willing to order that they give you a shower later. If that's helpful, whether it be tonight or tomorrow morning, okay? So even though you're gonna stay close by, I'll make sure, I'll work with the jail to make sure that you're given that opportunity after we're done for the night, okay?
Yeah, at least let me take a shower.
6 souls.
So I've been
Then I will
told
have
there
to-
is a question that will be coming out shortly, so don't go anywhere.
6 souls.
So I gotta have a fresh
What?
defendant.
I said, don't choke me.
Choke you?
Yeah, because you know what I'm about to say.
What are you about to say?
Subject matter jurisdiction.
Fuck you.
You knew I was about to say that.
Sir, I'm not gonna address
Wow.
it. I already-
Fuck you.
All right.
I'm sorry.
There
Wow.
are requests
I know
for
it's
the
Mike's
exhibit.
stream.
Oh my goodness.
Is that his number? It
Now
doesn't
he's
sound
just
like
all.
that.
Unbelievable.
I apologize, Mike.
Unbelievable.
This guy is
No, I
shameless.
genuinely apologize, but I could
I need
not.
to know the number to tell the parties who the fourth person is, because I'm not gonna say the name on the record. They have a request for 3 exhibits, 15, 5, and 55. Number 11 is the 4th person.
You said 15, 5, and
55. So I can pull.
Well, we didn't have any boots on the ground for this one,
15
so we don't know who
map.
that juror
15
is.
the map, yeah.
No,
Any
we do
objection to
not.
the map, sir?
Yeah, I want you to rule on everything.
Well, I was gonna go one by one. So I'll start with exhibit 15, which is the map. What's your position on that,
Again,
sir?
like,
Oh, good
Subject
Lord, they do
matter
want the map.
jurisdiction.
Oh, that makes
Position
sense.
is, at this point, what is the relevancy of the map? I think it's been seen a million times. I know about heart
Maybe
now.
see the-
That's probably the only one I know about heart.
Well, what's the state's position?
Yes, we absolutely, there's no reason not to send that back there, Your Honor. There's 76 counsels they need to work through and to assist them in identifying which victim is which and which group they were with and where they were on the road. Absolutely, there's no reason to hide that from them. It's helpful to them in their deliberation.
All right, I will send exhibit 15 back to the jury room. It is an exhibit. And there really is no reason not to send it back that has been identified by the parties. All right, the next exhibit is exhibit 5. That is the photograph.
Oh, sweet Jesus. What?
Seeing as how there was supposedly 2 incidents, one of which didn't even happen, which the prosecution sent paperwork to acknowledge that it never happened. So it's too dicey with that. What incident would 5 be referring to? One of which
The
never
battery
happened.
count.
And one,
It
It's
would
going
refer
in
to your
there.
murderous rampage.
I don't even know what I'm looking at if I look at 5.
That's his argument. I don't know what I'm looking at.
What's the state's position on 5?
Again, Judge, there's no legal basis to exclude that from the jury. There's nothing prejudicial. It's a single photograph. I should say overly prejudicial. It's a single photograph of a single person showing the injuries that are alleged to be associated with count 77. It's directly relevant to their deliberations.
There is no count 77.
Count 76. You are correct. It is count 76, not 77.
See why I'm confused?
Well,
Everybody
there is
on
amended
God's
information,
green
and I
earth
clearly
knows why you're
instruct the jury at
confused
76
because you're
counts. Be that as it may, I'll find that it is proper for Exhibit 5 to go back to the jury, and that will be sent to them. Now, Exhibit.
Okay, that'd be a no.
How long is that video?
15 seconds.
So my inclination, and I'll hear from the parties first, and then I'll give you my inclination. So any objection to playing for the jury Exhibit 55?
What exactly is in the Exhibit 55? I don't.
Oh dear God!
It's a
The
video
average
from
Evidence.
person in this chat
eastbound
would be a
showing
better
where
attorney
Granny
than
struck.
you. I've said this before. I will say it again.
You wanna
You
preview
could
it?
pick any human being in this chat right now, and
Oh
they
my
would be a
goodness.
better attorney than you. You
Deliberation.
God-forsaken dummy.
What I can tell you
Yes,
is
I want
do
the
allow
judge
it,
to
since
answer what's
I
in
would have
Exhibit
to- we'll
55 is
verify that the
evidence of
technology is
your
working,
guilt.
and then
And
I
they
would
wanna
play
see
it for
it.
them twice through. And we would watch it at the same time as they're viewing it. Theirs is just me in the jury room. But I'll preview it for Mr. Brooks so he can see it first. Well, the state will preview it.
Love it, Kathy.
All right, your response, sir?
Yeah, I don't object to it.
Of course he objects. You're right. You know, every
Can't
time.
find a
Every
reason why.
He doesn't know what he's objecting to, but you know, that's a thing.
I guess my objection would be
Don't guess. You should know.
Well, it would be hard to say why the jury would request it.
It's introduced into evidence. Nobody cares why they're
I'll just
requesting
let you
it.
rule on it. I don't particularly. There's so many videos that's kind of like the same video anyway.
Well, Exhibit 55 was received by the court. It's relevant to the charges in this case, and I will show it to the jury. I will work with Teresa and then the.
That means they don't like you,
to
asshole.
ensure that the
They're
technology is working when it's up and
making
running.
sure.
I will play that for them twice through. This is what I have proposed to write on the note back to the jury as it relates to all three. Exhibits 15 and 5 are attached. Exhibit 55 will be played for the jury 2 times, hyphen the clip is 15 seconds. And then I will initial that and date it.
Any reason why we need to be played twice?
And I just would note that the jury foreperson wrote yesterday's date.
Who gives a shit?
It is the
They
26th.
asked.
My date
what
will
they
be
get.
indicated. Obviously, they didn't get the case until today.
That's
so it's
called
just
the
a
jury.
error on their part, putting the 24th versus the 25th.
To be doubly
They don't have
sure
their technology with them, so I can't really fault them for that.
that you're guilty.
Any
Now,
reason
Clerk,
why
if you
it
could-
need to be played twice?
That's my
Yes, the
preference.
reason to play it twice is because you're doubly guilty. You
So what about if they
you
requested
murdered
a long video?
6 people.
Then I'll make a
and
determination then.
Injured another 60 and change.
I find that
If they
since
would
we
like
got the
the
new
video
technology,
of that,
easier just to do that and play
they're
it twice
entitled
than
to
bring
it.
them out, and for them to say stop, and then can you go back and can we watch it again? Because that's my experience. So I'm really trying to avoid that. So we'll stay out here, and then we'll work to. They'll have to pause their deliberations. So we
If
can interrupt
anyone's
them and get
curious
them the
about how I
exhibits.
feel, I think I've
Make
made
sure
that
the
clear.
Technology is working. So if the state wants to have that ready to go.
Well, they won't deliberate that late, but the judge has to stay there when it's
Return for
there's
value.
action. Like right now, she's got no choice. She won't leave now because they'll
She's
either
gonna
come
let
back
them
with a
run as
verdict
long
or
as they
decide they want to
want
go
to.
home soon.
I don't think they want to go to a motel. I think they want to be done tonight.
Yeah, I think they'll stay late.
I hope so.
Just to get her done. For sure.
Let's think about the people who are really put out here, namely Law Talk with Mike and his guests. I mean, we need a verdict.
I've been dealing with this since Wednesday, and I was the one that roped you into this.
Is there audio with this, or is it just video?
Just video.
Okay, thank you.
Thank you, Susan. I appreciate that.
Ah, my Northern Michigan peeps. I love it. That's what I'm talking about right there.
In Florida, we'd put him out of his misery. Although I suppose apparently not, because shockingly we're incapable of doing that either.
Yeah, without getting into further detail, there were drugs involved that people were giving to me that ended up being glue. Like I smoked some glue and stuff. I thought I was smoking crack, and
What I would give to sneak that into the judge's computer right now, as Exhibit 5.
I actually think, because what is it right now? 7:30 and change over in your time zone? I think she might run them till 9 o'clock, and if they can't come up with a decision, then she'll dismiss them. So there might be another hour and change. Which is a terrifying concept that I think just was wrapped around both of your minds.
You didn't say the cat jumped on his wiener, did you?
Oh, man.
I'm developing quite the clip library over here.
Oh, you're doing a fantastic job of it.
Come on, give us a dancing Blandino. That's what the people want.
Is it on? All right, the video was played twice. We'll wait and see if they have any other questions.
Your Honor.
Yes, sir.
About this Reddit, is that how you say it, Reddit?
That's my understanding.
Shut up, you idiot. You know exactly what you're talking about.
This particular person is who the email was sent from, the person at the top of the page?
Do you have the email that has the 9:10 a.m.?
Oh, good Lord.
Yes.
I know,
Does it
I'm
identify
plugged
have
in
any connection
to what the
with
people
trial
want.
in any way?
I'm leaving the entire investigation in the hands of the sheriff's department. I can't answer that. I'm sure they're looking into it though, because that's a good question.
Oh, dear God.
Yes, Honey Badger. I am.
That's precisely why I want to see them destroy him. He did something that really pisses me off. He took something that is a local tradition that's supposed to bring
All right,
joy to
I'm
people,
going to step off. Obviously, the courtroom remains.
And
turn
ruined it
into
forever.
an absolute
You know, if there are
carnage
any additional
fest
questions?
in front of children,
Subject matter
including a
jurisdiction,
child
Your Honor.
who died.
Oh, sweet Jesus. What?
I don't have any patience for that at all. I would like him to be destroyed. I'm sorry if people disagree with my opinion on that matter.
Oh, how great would it be if the investigation into the Reddit clip came back to him or an associate of his? That would just be the cherry on top.
There's a decent shot of it. Because where else would that have come from? I don't have any fun in me tonight.
Barb, have you considered being a dancing Blandino as an alternative?
No, although if it pays well enough, God only knows. I just don't have the fun in me right now.
Oh, someone else who asked the investigation into what? The investigation into the Reddit, into that subreddit. Who sent that, claiming to be a
Who cares?
juror, you know?
To some extent, who gives a damn? This is a BS defense tactic at the last minute that nobody cares about.
25,000.
He has 6
That's the assessor
life
now.
sentences.
I know, it's ridiculous, isn't it? It's stupid.
You're talking about $2,500. Yeah, you're going
Here,
down.
give me, no, ma'am, you're right. It is crazy. Let's change that. Bond's 50,000.
And by the way, not for nothing, Ben, I appreciate you giving a little bit more levity because I just don't have it in me right now.
Well, good. We don't want to learn anything either, so.
Oh, good Lord, they're
I'm not
back.
trying to educate.
I'm just
I'm
messing
just
with you.
pissed off.
They just said, can we see Exhibit 55 at 40% speed? Obviously, I don't recall specifically if this video was shown at a reduced speed, but many of the videos were shown at reduced speed during the trial. That was allowed. I think it's proper to also show a video clip to the jurors if they request it at reduced speed.
They're requesting
So I'll
additional
grant the request.
What is the
evidence.
significance?
The significance is the jury's requesting it, sir.
I'm saying at that speed.
To see
That's
it
their
better.
request.
That's why
I can't
football
tell
has
you the
slow-mo
significance for them. I
replays.
don't want to speculate.
You don't need
But I
that.
think it's proper, given the technology that we have available and what was done during the trial. So I will allow it.
So why even ask?
They might give him an acquittal.
Because that's what I'm required to do, sir.
They're not going to acquit him.
Why would they ask for the additional evidence?
Any questions I ask? From your name?
Mr. Brooks, I'm not going to relitigate your case right now.
Somebody in that
And
somebody in
I've
that
made my
jury
decision
room
on
is a
subject matter
holdout.
jurisdiction, so your request that I address it once
That could
again is
be.
denied.
Of course it's denied. Of course, because you can't prove it on record. Come on now. Has yet to be proven. It has to be proven at some point.
Yeah, I'll
Do
go
I
have a
gotta
drink
go
and
do
smoke when I want to.
the song and dance?
I'm not gonna hear it
Oh
from
my
you.
goodness.
God. This is
Are you ready with the 40% when they are?
mind-numbingly stupid.
Are we doing it once or twice, Judge?
Just once.
All right, the next person that tells me to calm down, I'm quitting the stream.
Don't say
There
that.
you go.
You're just gonna.
It's in your hands.
That's 40% speed. Yay, nay.
Turn yourself into jail right now.
The video clip is now ended with the state just confirmed the speed at which it was just played.
Yes, 40%, Your Honor.
Thank you. All right, let me know if there's another question. The court's going to step off. Obviously, we'll remain open.
I would say so, Nigel.
Oh, Lord. I am genuinely terrified as a matter of practicality. By the way, welcome to Law Talk with John.
I'm genuinely terrified that they have a holdout, and that's going to be an issue.
It'll be fine.
You think so?
Yeah, 11 against 1.
I
don't
do.
know. How many holdouts do you think there would be?
I thought the same thing about the Parkland shooter, and it apparently turned out 3-9. Granted, that was on death, so that's a little bit different, but I was shocked by that one. So the fact that they're requesting additional evidence, that's not great.
Yeah.
Sometimes I feel like there can be a stigma. I keep a lot of things relating to my sickle cell to myself. A lot of people don't really understand, and I don't expect them to, so I just do what I know is best for me.
I'm not going
The
to
heck was that?
make any comment on that.
Was that one of your clips? Was that one of your ads? Mike, is that
was
your
an
ad
ad.
in your ad algorithm?
No, it was an ad. It's an ad because I apparently I don't have YouTube Premium.
Yeah, but the choice of ads has something to do with what you watch. So I'm not going to say anything.
Or is that the, well, maybe we could, that's the algorithm for.
I get
who's this
that. I
law
get
and
that right
crime?
all the time. I can't imagine what it would be related to. I don't know what you're suggesting here, but you might want to pull back. You might want to back that truck up.
Oh, dear.
That's not ground you want to tread on in this circumstance.
No, Beck, I'm not confused that he gets ads. I'm confused why he gets that ad.
That was kind of my point.
Mm-hmm.
You know, I'm asking about his algorithm.
That was also my point. Like when I look up ads, it's usually for depression or like anime bullshit.
Okay. Okay, John's in timeout. John's in timeout for oversharing. Take a nap, John. We'll be back. They'll come back with the verdict here in a little bit, brother. I love you, but we're saying too much here.
Could
Yes,
be. Susan,
that's
that
the
might
sort
be
of
a-
thing. There's no way. I just don't see them coming back. Someone says, "Oh yeah, I just think he's not guilty on all counts." I just don't see it.
No. Yeah.
I suppose anything's possible, but you have videos of him driving over a crowd.
From my perspective, honestly, I think that she would like this to be done tonight. So if that causes her to drag them in, it's not right now 7:47 p.m. If that causes her to drag them to 8:30, they've gotten their dinner.
Yeah.
I don't think they want to be sequestered for a night. So maybe we'll get it.
All right.
I just don't know.
I'm going to take a break. I'll be back.
All right, cool.
We'll see you.
I'm going to go take my time out and cry in the corner.
Go take a nap. I'm gonna leave this on as soon as there's activity. I'm back. Stop it. Let's face it, it's the best part anyway.
All right. Hello, hello. Welcome to Law Talk with John. Welcome. It's an absolute pleasure. Mike made a terrible mistake. He kept me in the studio. So, while we're waiting, I am happy to do sort of an AMA and ask me your questions, and I will do my best to give you my answers as long as they are tasteful and within my knowledge and ability to answer. Bye, Todd. What law do I practice? Historically, I have practiced medical malpractice, general liability, employment liability, and first-party property. So generally speaking, it was general civil defense. Why law? Because I did not make it in Wall Street. No, honestly, God, I screwed up at calculus, and medicine and finance required calculus, so that didn't go so great. So I ended up with a political science degree and ultimately went to law. I don't know about that one.
John.
Yeah.
Make yourself useful and find the Reddit post so we can post it here. I don't know how to do that.
What?
I need a pre-boomer brain on this.
Wayfair's Way Day is back. Get low prices on thousands of items for your home.
Right.
Shop bedroom furniture from $79 and area rugs
Don't
up to
keep flooding me
80%
with
off. Shop
freaking
Way Day
ads.
this October 26th and 27th.
I was trying to entertain your
Wayfair,
chat.
you've got just what I need.
What is Wayfair? I don't know what Wayfair is. I've never been to Wayfair.
It's not a thing. It's literally, think about Amazon, but it's BS IKEA furniture.
Okay, so I'm just telling you, these ads are not representative of me. There's nothing embarrassing, but obviously the first ad's not applicable to me in any way, nor is the second.
All right. Give me a second. Let me figure out the Reddit situation.
I might have to break down.
What was it that they said that Reddit had on him?
I don't know what the subreddit is, but if you go Googling around.
If you tell me what it was that they had on him, I can find it much faster.
Well, it's I bet there aren't a lot of pro Darrell Brooks. I think it was like free Darrell Brooks or something like that. It had some ridiculous thing like that.
All right.
That would be my starting point.
This is how research happens in real time, folks. You get the partner telling you...
There, justice for Darrell.
All right, cool.
This
Thank
is
you,
what happens,
KDS.
guys. Welcome to your little piece of being an associate at Mike's firm. The partner tells you, I just need this, figure it out, however, and you go from there.
Find me some case law that supports this proposition. That's not the law. There's no case law that's. I don't care. I said find me some
I am
case law.
goddamn good at that. Do not ever take that one away from me.
Every associate's had that experience many times.
Absolutely. All right. Okay.
I'm trying to relax. Stop making me laugh. Damn it.
So what is it that I'm looking for? Because everything on this subreddit is absolute garbage.
Well, yeah. Everything on Reddit is garbage.
Yeah, I know that.
Let's take it out. Let's take it out a level.
Yeah, they have a bingo card. That's kind of cool.
Okay. We now have that DB just posted on Reddit. I mean, that could be him. It could be 1,000 people pretending to be him. I mean, this thing's going to blow up now.
Yeah, clearly. All right, do you want just the general overhead or do you want something specific? What am I looking for you?
I want the post in question, but I don't know what it is. And that's a fair, I understand. If you can find the post in question. Somebody tell us, what did it say? We were just both listening to it, by the way, but we're both delirious.
It's been a long day. Are they complete fools? I'm glad this subreddit is up. No, that's not it. All right, that one's actually funny. Retry an estate with capital punishments. No, that's obviously
Here,
not.
I've got a funny Yesenia story now that you sent me this, which is actually kind of funny. The Dagfin says, is Yesenia supplying Mike with intravenous coffee? No, she's not. But I was talking to her today while we were trying to do business. She knew I was streaming. And she's like, I was thinking about sending you food because I know you haven't eaten. And she knows me, and she's right. And she said, but I also know that if you're streaming, you won't pay attention or notice, and they will never get the food to you.
Also probably true.
Also true. That's what happens when you work with somebody too long.
Oh, that's awesome. She's the best.
Yeah, she's sweet.
You are extremely lucky to have somebody like that.
Indeed.
1025. Somebody send me 102522 post. All right, let's see if I can find it.
Oh, damn you, Emily Baker. She would have the subreddit.
Does she have it?
Damn her. I'm sure she does. I'm sure she does.
I mean, you have her text number, I imagine. I do not.
I mean, I probably shouldn't mention, you know, I probably shouldn't mention a competent channel covering the same topic tonight.
Why not? Who cares? Everyone's literally just on verdict watch.
I'm at 7:47.
Here we go.
Person provided a question through the bail.
Oh my God.
If we request exhibits 3 and 4, exhibits 3 and 4 are videos. They are the videos from White Rock, I believe elementary
No,
school.
that's not okay.
Door 1 and door 2.
Yes, correct.
How long are each?
Exhibit 3 is 4 minutes and 14 seconds.
Dogs are all
Exhibit
good.
4
6 minutes or so.
is 6 minutes and 58 seconds.
7 minutes.
Okay.
Come on, Mike. You can't keep
My
your shirt on
inclination would
after
be to play
8:30.
each one time, since they're a little bit longer, and play them one after the other. From the state?
Agreed.
From the defense?
Objection.
Noted for the record. Any specific reason, sir?
No, I don't know what objections are. I just know I have to say it.
The significance of both videos.
Their evidence,
They've
sir?
already been accepted into evidence, you idiot.
And the jury's requested to look at them. So I will be playing them for them. We'll do Exhibit 3 first, and then Exhibit 4 shortly thereafter.
I am terrified by the fact that
Will you
the
be addressing
jurors
subject
are
matter jurisdiction
requesting.
on the record?
Oh, shut up.
No, I will not.
Is that a judicial determination, Your Honor?
Yes, it is.
I can't, oh, you're not asking me.
Is that a tacit agreement, Your Honor?
All right, they are ready.
The arrow in the middle of.
Oh, we can get rid of that. Clear annotation.
Is that a tacit agreement, Your Honor?
Go ahead and play Exhibit 3 in its entirety. Here you go. You need. You have that one, right? Yeah, I grabbed it. You can stop that one. They're asking it to be stopped. Any objection from the state?
No.
From the defense?
No.
Okay. All right. Switch to Exhibit 4.
It's always dangerous to try and get into the mind of the jury.
You're not asking me.
Is that a tacit agreement, Your Honor?
All right, they are ready.
The arrow in the middle of it.
Oh, we can get rid of that. Clear annotation.
Is that a tacit agreement, Your Honor?
Go ahead and play Exhibit 3 in its entirety.
Okay. So to start with, I obviously shouldn't be here. I'm not allowed to look stuff up about the trial or really have any connection with the internet, but nobody actually follows sequestering rules. Anyway, hence I am obviously posting anonymously. I accidentally wandered into here a few days ago from subreddit drama, thread on my main Reddit account. Here is my opinion on the trial. First off, I think it's pretty obvious due to chain of custody that the defendant is in fact Mr. Brooks, and he did do it. However, I've had throughout this trial doubts about the various aspects of the case. This judge is clearly biased against Mr. Brooks. Blah blah. It's fake. But now we know what
That
we know
can't
what it was.
possibly be
Any
real.
objection to stopping that video?
No.
All right, Mr. Brooks.
No.
All right, it'll be stopped.
Judge, for the record,
If
this one was
that- if
stopped
that
at
was
1:38.
in any
Do you know
way
what time we
true-
stopped it on Exhibit 3?
35.
I want you to pause.
Thank you.
They would not have requested a review of these exhibits, in my opinion.
All right, David. I think you might want to stay close by.
Was that a good way to reach the state?
I'm not sure.
Yeah.
Oh, Lord. Mike, you're the one that has the Reddit post. You want to go through it and join me in?
Yeah, somebody tweeted it to you too.
Why it's BS?
I can barely read. I was trying to display it, and to do that, whatever. I did it. But
Is that a tacit agreement, Your Honor?
Oh, you're asking me.
That's all I've got of it, though.
All right. So, fine. Then I'll read it.
I read it. I just read it all the way down to the judge is clearly biased against Mr. Brooks.
Yeah. I got that feeling from when we were in the room, and my eyes have been opened to how she acted towards him when the jury was out of the room. Clearly, she is not an impartial judge and has been trying to belittle, demean, it misspelled, bully, and pull procedural tricks on him fairly infrequently. No, this is not legitimate by any stretch of the imagination, in my personal opinion. Could it be? Sure. Is there a chance that there is a juror that actually writes this way and behaves this way? Yes, it could be. Do I think that's the case? God, I hope not, because I've had a lot of...
It doesn't really stress me out, nor do I don't like that they're asking for so many exhibits, but it's very mild. It's not my favorite. I prefer they just came back with guilty. But even that, I could see a jury. You got 12 people, and they're saying, yeah, we're putting him away for the rest of her life, but they could be fussing about like one count. Well, I'm not sure about the first one, but after that, he carried on. Something like that.
No, because so this is where I disagree with you. And I don't know.
Be done for the evening and come back tomorrow.
Okay.
So I said they should assemble. We'll get the alternates because they're sequestered.
Sounds like they're coming back tomorrow.
Yeah, it seems like that's going to be the case.
That might just been a hot mic situation, though.
Well, in either circumstance, I think it's probably appropriate for...
It's
us
8 o'clock.
to take a break for the judge to state her piece, and then we'll be done.
To break for the day. I need to basically tell them that because they're breaking for the day, they should not continue their deliberations while sequestered until they're back in the jury room.
And maybe
So
should
I'll
stop
read a
posting on
modified
Reddit.
Kind of version of instruction 50.
I'd flip you the bird, but YouTube would not
we are in the
appreciate that.
Subject matter jurisdiction,
I decline to address that further, sir.
will it be proven for the record?
Sir, my earlier decision, I stand behind it, my written decision.
Your written decision that's not based on any law or fact?
Hold on.
Did you like him, Tatted Cat? That's what I want to know. Was Monty okay?
Probably not. Plaintiff's attorneys suck. Present company excluded.
Oh, God. Yeah, if it's a hung jury, you'd do it again for sure. I don't think it's a hung jury, but okay.
Oh, God help us.
They would try it again.
I think they would try this one again.
Oh yeah, you can't let this go.
This is not the kind of thing where you hope for a hung jury and they just decide not to re-prosecute. That's not happening here.
Yeah, you got.
Sometimes that does happen.
You get a hung jury on a tough to make egg bat. Yeah, they probably won't they probably won't retry it. This
no. There's no shot in hell. They don't run this again.
Thank you, Kimberly. So it looks like 8:30 in the morning.
Other alternates, they're in a different place.
John Weirds, I actually think that you might be right about that, and I'm hoping that's what they're.
I thought it was 2 people that got excused from the jury.
Because it means that the top counts they've already decided.
No, I'm saying I thought
I
it was
don't
2
know.
from the
That's what
16th.
scares me.
No,
I changed my shirt a lot.
Well, you did say 2. You said one had got excused before, and then another one was getting excused.
No, I only excused one. We've had 15 since the first juror was excused.
So what happened to that second one that had the COVID scare? What happened with that?
Mr. Brooks, I addressed all of that on the record. I'm not rehashing that now.
No need to get in your feelings. It's been a long day. I'm tired too.
I would agree.
Then fine, go back to your cell.
But I'm not.
Enjoy your
Just
cot
letting you know I'm not going to rehash
for the
that
rest
stuff.
of your goddamn life.
I just thought you said 2. You said 2 on the record.
I don't have a lot of patience for him. I think people know that.
IG.
Who's giving him folders? Because those look really nice. I'd like those.
I think Giselle speaks for us all here.
All right.
And I think that's likely to happen, actually.
Well, I don't particularly intend to follow that advice, but the first half, maybe a little bit.
Thank you, everyone. Please be seated. The record to reflect, I have the 12 jurors who have been deliberating, plus the 3 alternates who were sequestered in a different jury room. I want to give you kind of a modified instruction from the one that you've heard many, many times throughout this trial. Of course, for the 12 who have already started to deliberate, do not deliberate unless you're in the jury deliberation room. And that will mean from when you are discharged here tonight until you come back tomorrow in the jury deliberation room. Do not discuss this case among yourselves or with anyone else until you are deliberating in the jury room. This order is not limited to face-to-face conversations. It also extends to all forms of electronic communications. Do not use any electronic devices such as a mobile phone or computer, text or instant messaging or social networking sites to send or receive any information about
At
this
least
case
we'll know
or your
over
experience as a
tomorrow.
juror. I realize you are sequestered. We've taken away all of those things, but I'm just going to keep reading through this. If you come in contact with the parties, lawyers, interpreters, or witnesses, do not speak with them. For their part, the parties, lawyers, interpreters, and witnesses will not contact or speak with the jurors. Do not listen to any conversation about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene either in person or by any electronic means. Do not read any newspaper reports or listen to any news reports on radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness in this case. Any information you obtain outside the courtroom could be
Send it to us.
misleading, inaccurate, or incomplete. Relying on this information
Yeah.
is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you are serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so despite your telling them not to, you should report that to me. I know you're not going home. You're going to another location, but do not discuss this case among yourselves with any other juror until you're
Yeah,
back
if you want to
in the jury
screenshot it,
deliberation
send
room
it over to me in a
tomorrow.
DM.
This case must be decided by you,
I'll
the
take a
jurors,
look.
based on the evidence presented in the courtroom. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decision in this case. After this trial is completed, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide the case solely on the evidence offered and received at trial. With that, you are all excused for the evening. We'll
Go
see you
get
back here
screwed.
tomorrow at 8:30 a.m. All rise for the jury.
One night in Motel, Wisconsin, and they're going to hang him up to dry. Tell me if I'm wrong.
I can't believe they decided to go there.
Nor can I.
They
But
didn't have a lot of time. I will say that.
they did
All
not
right,
have a
thank you,
lot of
everyone.
time.
We are in recess. We'll see everyone tomorrow morning at 8:30. 8:30 a.m. I trust that the jail will give you a shower. So whether that's tonight or tomorrow morning before you come back.
Lauren disagrees
But I
with
will
me.
order that. 8:30. That's when we start court every morning, sir.
No, it haven't been. You did some switches.
I literally think one night in Hotel Wisconsin, and we will probably. What do you want to take? The over/under on a verdict by lunch?
I'm just kind of disappointed because I wanted it to be done now.
I want it to be done too.
But that's okay. That's okay. That's another bright and early morning with me and John. What could be better?
Oh, Lord.
Strung out from over a week of this trial. Well, no, because there'll be interesting stuff that happens. But I don't think the deliberations will take long in the morning either.
I don't think there's going to be a lot more interesting that occurs.
They got it. They got a good start. They got to get us a night's sleep. Be annoyed that that they're inconvenienced and out of their homes. Then they will come back and say, "Okay, let's do this." And
I'm teed off that they requested additional evidence, which suggests that somebody is a holdout.
Yeah.
What do you mean? Yeah.
There's part of them
you
too
were in
that
a
just
civil
wants to
case,
look like they took it
if
seriously.
you were in a civil
and didn't-
case and you had a jury of 6, and they did not come to a unanimous decision in the first 4 hours, and they requested additional evidence that was actually factual in nature, tell me, would that or would not that bother you? It would make me feel great as a defense attorney.
Right.
It would make me feel scared on the other side if I were the plaintiff's attorney.
Yes, I think it's a bad fact, but a very, very limited bad fact.
Okay.
Like I think that the chances of him getting some weird like hung jury went from 1 in 1,000 to 1.5 in 1,000. Like you know,
Okay.
but having said that, I agree with the notion that you would anything other than a quick guilty is a surprise in the wrong direction for me.
Look, I put it this way, and the partner that I was working on this particular case disagreed with me. But the issue was they were asking about something that equated to actual kind of, so in this case, guilt, but in that case, actual liability. And I was like, you know what? Look, if they're asking a question about liability, we're good. We got this.
Mm-hmm.
And the partner was concerned, but I was absolutely correct.
Yep.
Because that's the only way that you get to look into that jury room. Like, we don't, as lawyers, get the opportunity to look into what the jurors are thinking. We don't get to go into the jury room. We don't get to hear what they're doing. The only thing we got is their questions.
Yep. The only indication you have is their questions. That's it.
And their questions are not great for the prosecution right now. Right or wrong, and I think that they'd absolutely be wrong, but it's not great. It's not where you'd want to go to sleep tonight. I'll put it that way. Is that fair?
Yep. Yeah, I think Ian's probably on point, but whatever. I agree with you. It's not good, but it worries me very little.
All right. Well, let's see. I just got over the Parkland nonsense, so maybe I'm a little bit damaged from that.
You're a little whatever. All right. Well, I've got to put the stream together. I will see you all guys. You all guys. I can't even think straight now. 8:30 in the morning. We will be there. We'll probably be cranky. We'll probably be short of sleep, but we'll be there.
That is most likely going to be the case.
We're not even guaranteeing. No, we'll be there. We'll figure it out. All right. Thanks a lot, John. Good night.
Right,
Good night,
always
everybody.
Thanks, Mike. I'll see you
in the morning. Bye.